Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Lava, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
We bring the jury.
The jury. Hello, internet
Good
besties and couch
morning.
potatoes. Happy Fukong Friday. Our favorite day of the week. Our favorite day of the week. And we've got more Laura Owens to talk about today. We're going to briefly watch her extremely brief trial management conference. That was the other day. Don't
Extremely
get too
brief.
excited. It was like a whole 3 minutes.
I got something to say about that. I
what's
would be
that?
so pissed off if I got up early, got dressed, drove down there, and
the
they were like,
courthouse?
2 minutes, we're done.
Right. Well, hold on. I'll be right back.
I would be mad. I'm just saying.
Okay, I'm fine. Sorry. All right. Anyway, good morning, friends. Hello, 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 Lady in Gray. Happy to see you. Oh, yeah. What else we were going to talk about today? I'm sorry. Ooh. So we also will go back to the timeline of 2024. We got a David blog, which is always a good time to hear what dumb shit he's going to talk about today. And we got ruling by Honorable Fisk regarding whether or not a new judge will be, present for the paternity trial that David's still arguing about. And then if we have time, maybe we'll get into David's bar complaint, which is going to be a whole nother trail on this story because it's technically still going on, if I remember right. I'm not sure exactly. I know he was supposed to have a hearing about it with the bar and everything in June.
Wait,
but
this is his bar complaint?
yeah, I believe so. Yeah.
I
think so.
thought he was complaining about the judge. When I read that, I thought that
Maybe it
that's what
is.
that was about. I don't know if it's somebody else complaining about him.
That's a good question. No, I think it's about him, but we'll find out. I don't know. We haven't read it, so we'll see. Now I lost everybody. Oh, there we are. There we are. Found you guys. So that is what we will all be talking about today. Let's see. And back to saying hi to everybody. Sorry. Hello, 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 Terry True Crime. Good morning. No longer birthday girl, but you know what? I know Terry. She celebrates her birthday all week. So if you didn't know yesterday was Terry's birthday, go ahead and tell her happy birthday today too. Why not? Double the birthday days, double the fun. So hello, April. So happy to see you here. Echoes. Happy Fukong Friday. Hope you're doing well. Hello, Say Cheese. Happy Fukong Friday to you as well. Oh, why wasn't that clicked? There we go. There we go. Happy to see you. Pam and Polly, so nice to see you. Bill, good morning. Good morning to you. Let's see. Hello, Winks. Good morning. Good morning, everybody coming in. So, guys, listen, before we get into anything, I just have to briefly say something. I didn't want to because it's fucking stupid. But unfortunately, people have been sending me not so great things. And I feel like that's not entirely fair. Now, I'm not going to sit here and I am not going to talk about it for hours because, quite frankly, I don't care. I don't care who likes me. I don't care who doesn't. All right. I'm here to talk about cases I want to talk about. And if you don't like me, that's fine. There's like 8 billion people in the world. Most of them aren't going to like you. So it's okay. But I feel like there has been some things said that aren't entirely accurate. And I like to play in facts, at the very least, to let people make their own decisions. Now, apparently, there's a whole thing about a thing going around everywhere. And all I have to say about that is that I stand by my original comment. The original comment that wasn't actually read, talked about, or shown. And this was my comment. Not that one. This one, somehow. There you go. You can read it. You can screenshot it. You can share it around. I don't really care. I don't care what your opinion is about my comment. It's my comment. It's my opinion. And I stand by what I said then, and I stand by it now. And that's, I do not believe dividing the community. It's pointless. It's silly. It's stupid. And I don't want to bring negative attention to the community either. So, end of story. It doesn't need to be talked about anymore. It's silly in the first place. And I just want that put out there to see that that's what I said. That was it. All of this for crash outs and breakdowns everywhere. All right. So please don't send me your messages. I'm not going to respond back to them. I don't care to have these kinds of conversations going forward either. But there it is. That's what it is. And I still stand by it today. So there you have that. Now, let's get back into what we're really doing here today. And that's talking about a real case with people with real problems, not other things. Thank you, Terry True Crime. I appreciate that. Thank you for the super chat. And yeah, I mean, I'll always keep being me. It's just the internet, guys. It's just the internet. All right. So let's do. Now, where'd my videos go? Oh, there we are. It's my first day, you guys. It's fine. All right. So we're going to listen to this brief, again, very brief. Don't get your hopes up. Pre-trial.
It's ridiculously short. I'm telling you, I'd be so mad if I got out of bed for this.
Yeah, right. Get all dressed up. But isn't that how court usually works?
I know it is. I know.
You go in there,
show up. It's 2 seconds
think
long.
something is gonna, whatever court it is. It's not even court specifically, but you go in, and then no.
I'm only going to speak to my experience when my daughter we were going through a criminal case, and the prosecutor would be like, "If you want to come, you can come." It was a status conference. It's just same like that. You don't have to. There's no reason to be there. It's going to be short. They're going to kick it down the road. Da, 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 da. And I was like, okay, cool. I'm not going. Even though my child was the victim in it. No. I was like, I'm not getting out of bed at that. When y'all finally have something for me to talk to or talk about, I trust the prosecutor. So I didn't even get out of bed on that one.
Right. Oh, by the way, if you haven't yet, please like this video. Lets everybody know that we're live. Puts us out into the YouTube algorithms. And if you're new, subscribe, hit the notification bell. Make sure you go over to our new channel, Couch Court with Llama, because we'll be moving over there permanently soon. I'll still be doing stuff here, but Couch Court will be over there. So make sure you go subscribe there as well. Yeah, do that. Everybody be like Hellville today. Join Couch Court from your phone and watch True Crime and Wine Time on the TV, whatever you want to do. We appreciate the support on both channels. So thank you guys.
Yeah, I'm usually in the chat on Couch Court with Llama. So
all right, let's go ahead.
In 2 chats at once. It's hard.
It is hard. Double the llama fun, or that too. All right, so this is brought to you today by All the Best Research. If you don't want our commentary, which I doubt there will be very much on a 3-minute video.
Have they met us?
Right. That's true. Hey, I thought we did pretty good yesterday with BAM and having 2 hours and like 40 minutes. Well, no, I guess it was like 2 hours and 20 minutes.
Girl. I had a lot to say yesterday.
Hi, Raz. Good morning. Hope you're doing well today. Thank you, Amos. We love you too, babes. All right. So anyway, this comes from All the Best Research. Make sure you go over, like their stuff, subscribe to them, hit the notification bell. If you want to watch this without all of our commentary, you need to refer back, go there and watch it and support them. So let's see how this goes. I don't know what all happens here. So
I wanted to look at the state.
This is CR 2025-007905, State versus Laura Michelle Owens. Time set for a final trial management conference. Can I get appearances, please?
Oh, there
Good
she
morning.
is.
Morning, Christian Reed on behalf of Ms. Owens, who's present with me at the podium.
Ms. Owens, can I get your name and date of birth, please?
Laura Michelle Owens, 5/14/1990.
All right, what are we doing today?
Your Honor, I filed a motion to continue over the weekend, asking for the FTMC and trial date to be continued 90 days and asking the court to schedule a settlement conference in the matter. We discussed that at the previous CCMC,
Okay.
and I'm hoping the court still has availability on August 28th. But
Yep, I got that booked.
Okay.
Mr. Leiters, the state have a position on the request?
No, in line with the settlement conference, that we hope to resolve the case. That makes the most sense to me.
All right, Ms. Owens, you're good with the continuance? All right, I'll find extraordinary circumstances, grant the motion to continue. If we could reset this about 90 days, please.
Trial date would be October 28th, 9 a.m. FTMC October 21st, date and time.
How is October 21st and October 28th?
works for defense.
That's fine.
All right, Ms. Owens, you need to be in my courtroom on August 28th at 2:30 for a settlement conference. Then you have a FTMC October 21st, 8:45 before me. Trial assignments October 28th at 9 o'clock before the trial assignment judge. If you fail to appear, warrant will issue for your arrest. If you don't show up for trial, it could occur in your absence. Stay in touch with your lawyer. New last day.
November 28th.
Anything else you need to talk about today?
What was the time on August 28th, Your Honor?
9 o'clock, standard trial assignment time.
No, I'm sorry, for the settlement.
Oh, that is at 2:30 p.m. August 28th.
Thank you, Your Honor.
2:30 p.m. Do I have that on my calendar? at
Thank
that
you.
time?
We're in recess in this matter.
I'll check that later. Well, that was it. I know, lackluster at best. But interesting. They are still keeping the settlement conference for, sorry, I have a dry lip, for August 28th for the possible plea deal. I don't know. They are already are keeping it. I don't know if it means anything either way. Probably just there as a safety. Either maybe
Yeah.
then they'll say yes or no, but putting the trial date on there too, that's just is what it is. I mean, neither one really says very much.
My
me.
thought was that perhaps maybe she's considering a plea on certain charges, but not all the charges.
Could be.
I don't want to close the door on that yet.
Could be.
That's just my thought.
I think that's equally possible as well. Because that's the thing with plea deals. But does she for the plea deal? They have to accept if she only wants to do a few of the pleas, because it could just be like the whole shebang. I don't know. We don't know.
I mean, I don't know if that's the stipulation. You have to plead to all or none, but usually they'll let you plead to some and go to trial on the others. Like it sounded like listening to the last one, her lawyer stated that there's a lot of evidence to the perjury. But that made me think, oh, well, there's a consideration that she'll say, yeah, I perjured myself on the stand, but artifices like the fraud, that part that she's going to be like, no, I'm not a fraud. I'm like those things that she's going to draw a line in the sand there. Yeah, I lied because I did, say I went to this one and that one I changed things on the stand. Yeah, she can't really go back on that, but she can try to fight the fraud. If she wants to stick to her story that I changed things because I didn't want Clayton to know where I went to get my ultrasound done, she can stick by that. That's her intention. She could stick by the fact that, she didn't defraud the court. She sent it to Neil, Dave Neal, on that ultrasound video. Like there are things that she could argue. I'm not saying she'll win. I'm saying she could argue that she didn't. That's not fraud to the court. That's fraud on a thing. You know what I'm saying?
Mm-hmm. Hi, Carmen. Hi, RJ. Happy to have you guys here this morning. Yeah, no, actually, I think that's a really good point. Because sometimes you don't want to go to trial with stuff that is an automatic yes.
Mhm.
You know?
Right.
But maybe some of the, well, I feel most likely everything else is an automatic yes as well. You do
Mhm.
bring up a very interesting point that her lawyer was like, yeah, there's a
Like,
lot of
you're not
damning
really
evidence
going to get
for that.
around the lies you said on the stand, but we might be able to
Right.
argue this to the jury.
Yeah, yeah, exactly. Well, excellent opinion there, and I think maybe that could be it. Now they said that okay, well, we're going to move the trial to October 21st, which remind me later to put these in my calendar because I don't think I did. And I still don't think I don't think that's happening, friends. Okay, I don't think it
Mm-mm.
will. I mean, if it does,
No.
okay, you know. Cool, but the fact that they asked for an expert, I don't think they've said or filed anything yet regarding the expert and who it is or anything like that. But I mean, that's a lot of work to write, to go through everything, write out a report. Then the attorney, her defense attorney, has to go through the report and understand it as well to give her the best defense. Doesn't mean it's defendable, but for him to be a good, to do his client duty as he should, he too needs time. So I would be very surprised, but they usually kick it out a few months and kick it again and again and again. Hello, AZ. Hope you're doing well. Happy to see you here today.
Can we just do a poll, like an unofficial poll on like when we think this will actually go to trial? Like, are we going for
Yeah.
summer of next year? We going for spring? Like, like, oh, this would be so appropriate. You know how when you have a baby shower, you do your poll and everybody selects a date they think the baby will be born. Everybody put like their
Oh,
name
see, I
on the
just thought you
date.
were pronouncing poll wrong.
No, a pool. No.
Oh, yes, we should.
Like at baby showers, they put the big calendar up and you're supposed to put your name where you think the date, the baby's due date, and then when you think the baby will actually be born. I mean, I think it's appropriate considering the fake pregnancies.
I love that idea. We'll figure out how to do that. I don't know how to do that, but yes. Oh, happy almost birthday in Octoberville. That's a great birthday present, right? Like, oh, that'd be fun. Um, but yeah, I don't think they're gonna be going, oh, Winks, thank you so much for your super chat. You're so kind and nice. We appreciate you too. All the love. Thank you so much. You're amazing and so sweet. You're guessing her attorney will quit if she doesn't take a plea? Maybe. What I do know, you know what I do, even though it's annoying, this was only like 2 or 3 minutes, but that for him to show up there, quite a lot of money for 2 minutes. It was at least like $500 to $1,000 at least
See,
added to her
we can,
bill.
we can have a 30-minute conversation about a 2-minute hearing.
That's true. That we can. Um, so hi to Montana. Good morning to you. Hope you're doing well today. Tanya says, I'm telling y'all her new lawyer will be dropping her in the next week or so. Back to a public defender. Date changed again. I mean, I personally think that, yeah, she's going to try to cycle through lawyers because she always has. And she is about delaying. Now, as far as, the expert, all of that, that is all normal stuff that should have been happening already, but it's happening now. But I'm not putting putting it past her. So, do we get 2 guesses for twins?
I'll
Yes,
allow it.
I'll allow it. Let's see. Hi, Dave. Good morning. Hope you're doing well. Oh, Echoes is taking us into the shower. Oh, it is a Fukong Friday, isn't it?
It is.
All right, so let's get to our next thing that we're going to read, which is one of our favorite things, and that is a blog from David. Oh, put that one up. There you go. All right.
All right. My brain cells just decided they weren't sticking around anymore. They're like, no, we've had enough.
No. Right? Echo's getting steamy in here. I love it. Oh my. I hope he's still
What
listening
kind
to
of
us in the shower.
what
It's
kind of soap
squeeing
do you
right now.
use? What kind of soap? What kind of soap are you using? I need the full experience.
Oh. All right. So where on the timeline are we? Oh, why do I have this up here? I can't read when it's on that screen. Only videos. Okay, hold please.
Hellville.
Um,
She said she's got one of those shower wall phone holders. Girl, let me tell you what a Ziploc bag will do for your phone.
yes. Who was I telling about the Ziploc bag a while ago? I think it might have been Mama Bear, but I was bragging about your genius because I do it now. Otherwise, I would never take my phone in the shower. I don't live that dangerously.
Right?
Okay. It's crazy to me because in my brain, we're still in like 2009, where if a drop of rain will destroy your phone. So, and my brain's like, no, it's definitely happening. And then Buffy
Ziploc
told me about
bag,
the Ziploc.
put it in a shower caddy.
And I can still press the buttons if I need
Yes,
to.
ma'am. It's
Um,
amazing. I'm cheap.
I
I'm
love it.
cheap.
Cheap but effective. Cheap but effective. And if you knew Elbow Feet, I still am like, oh my God, my phone is going to end up on the floor of the shower at any point. Of
Yeah,
course, Daniel.
you're
Of course,
good.
we mention you. Of course, we do. There's Savage. Good morning, good sir. The Ziploc won't hold it to a wall. Fair point. But the suction cup things, I don't know if it's
Mm-hmm.
just like our shower or if other people have this thing, but like Elbow Feet loves using suction cup to things on the shower, like his loofah or whatever. And then in the middle of the night, it falls down and scares me while he's sleeping, because of course nothing wakes him up. And it happens every day. And I'm just like, stop
Okay,
doing it.
but yeah, use like the tape. What is that tape? That miracle tape that everybody likes to put on their walls. That's what we did.
The command stuff or
Yeah,
whatever.
it's like the command strips. We have those in there. Just use the heavy duty ones.
Yeah, don't bring a toaster in there.
I mean, just don't get it wet.
Just don't get it wet. Yeah,
Don't drop it.
I can't use
just kidding.
suction cups either. They also don't like me for some reason.
Oh, what is alien tape? Is that a
What
thing?
is alien tape? What does that mean? Speaking of, well, it's not entirely relevant, but it is. Have any of you watched Pluribus? I know I'm late to the Pluribus party, but I finally got
Yes.
around to my queue. Loving it. I have 2 more episodes to go, but B is like 3 behind. Anyway, loving it. Highly recommend.
Definitely a great example of hive mind.
Yeah, it's also done by Vince Gilligan, who also did Breaking Bad and Better Call Saul. It's on Apple TV, but I really appreciate it. It's like a kind of a fresh, different story. It's humorous, but also kind of the first episode kind of makes it seem like it's a horror story, but it's not. Well, it is in a certain way. But anyway, it's brilliant. So I'll be finishing that, and I'm really excited about it. So you love Pluribus? I'm not done, but in the Discord, I'm gonna make in our TV section, I'm gonna make a Pluribus thing so we can talk about it because I need to, even though I'm super late to the party. Hello, Nord. Happy to see you. Teresa S. Good morning to you. Happy to see you guys. All right. So, yes, I know, right? Mary's like, let's just talk about all of the things everywhere. But yeah, I'll do that too. Silo, I think Silo already has one in there. I haven't watched. Oh, wait, no, that new episode comes out today for Silo. So I'm caught up. So yeah. All right. Anyway, let's get to David's blog, which is always a fun.
Oh.
Now, hopefully Rule 26 isn't mentioned a lot, but you never know. You guys are either getting super day wasted or I don't know. There's Elbow Feet.
Hi, husband.
You still haven't watched this week's Hot D? It was good. It was good. The next few are gonna be wild. All right. Anyway, no TV. We're done with TV talk. We can talk about it in the Discord server because I'll sit here and talk about it all day. All right. So on the timeline here, we are at July 18th, 2024. Now, David has asked for a new judge, asked for a new trial, is very upset about the judge's dad and thinks that the dad influences everything of a grown-ass professional woman. It was all very, very weird.
The tantrum.
The tantrum, really. Excuse me. And so he's coming around with a blog post for some reason. So let's see what he has to say today. You won't believe this. No, really, you won't. But I do not want to blog about Owens v. Echard anymore. At least not at this current phase. But I'm going to do it now, and I'm going to continue doing it. But I don't want to. I don't want to do it, but I'm gonna. I have better things to do, and the case isn't at a place where there's much important new stuff to discuss. That will come later, probably, but not now. On the other hand, with so much inaccurate information being spread every day by the JFC cult, this puts me in a difficult position. Do I ignore the BS as I've tried to do since last month, or do I respond and try to set things straight? That is an odd topic.
Man, that's on the nose.
I know the JFC cult hates me with a white-hot passion, but you can't deny what recently happened with the notice of change of judge. At least some of the less extreme JFC fanatics stopped for a moment, looked at the facts, and realized, Jesus, Gingras has a valid point we can't refute. I don't believe anybody said it just like that. Like, an epiphany.
I thought to myself the other day, Jesus, Gingras has a valid point we can't refute.
Hey man, we've given this guy credit where credit's due. He's not wrong about some stuff, but like, it's never like this epiphany. And then he says, don't deny it. You did. Oh, okay. So even though it is really, really, really hard to change the minds of people who made up their minds months ago, and even though I have seriously enjoyed not talking about this case, there is still a glimmer of hope. There is still a small chance that some people might stop drinking Clayton's Kool-Aid, even just for a minute, and they may finally realize the truth, that there are serious problems in the way this case has been handled, and those issues deserve public attention, concern, and perhaps corrective action. I'm going to respectfully disagree with a lot of that, David, but okay. Tell us why, though. Okay, so I basically have two options that I'm going to spend the next 4 hours talking about on this blog post. One, allow the JFC's cult's one-sided and often incorrect narrative to be the only public commentary, or when important issues arise, offer my own comments to explain my views about the legal rules, procedures, etc. I don't love either option, but I think the harm that comes from option one requires me to go with option two. With that said, here's the deal. Earlier today, Judge Mata issued a one-line order denying all my post-trial motions. Motion to vacate the judgment, motion for a new trial, etc. Honestly, most of the time, this is what happens anyway. Every trial we watch, they're always filing this right afterwards, right? They want a new trial, judge, the whole thing. I mean, it's pretty standard. So this is not like a one-off case. I'm pretty sure most judges probably get it after every single case, right? You're found guilty or in cause of. And
I don't think most people try to remove the judge after the case is over.
No, but it does happen. It does happen. So, hi, Cindy. Good morning. Happy to see you here. It's okay to be late. It's fine. 2 times speed. Good luck with that.
Maybe on a criminal trial.
That's
a
fair.
criminal crime.
Oh, a criminal
But
crime.
civil, come on now.
That's true.
Civil, come on
That's
now.
true. Well, in fairness, Echoes, you've actually been mentioned and stuff, so I don't blame anybody that has and their opinions on any of that. That's for sure. All right, where was I? Is that a big win for Clayton? Obviously, JFC thinks so, but here's why they are so wrong. First, as everyone knows, on July 8th, 2024, I filed a notice of change of judge for cause. The notice was based on Rule 6.1 of the Rules of Family Law Procedure, which allows any party to ask for a new judge when grounds exist. In this case, we argued Judge Mata was biased and that she had acted improperly for reasons explained in the notice, which I just like, no, that's crazy. I understand most people following this case are not lawyers, and that's fine. But at the same time, if you are not currently licensed to practice law in Arizona, and if you do not have substantial experience practicing civil litigation in Arizona's trial and appellate courts, you really need to be careful about rushing to judgment regarding what you think the law says. Oh boy. Oh boy, David. Oh boy. Oh boy. Well, things did not go well for you with or after this trial or in appellate court or any of those things, but okay. Right, the win was already stated, but sure, David. Sure. Yeah, that definitely happens, or they did, or something along those lines. I understand. Oh, wait, I'm sorry. Although I don't follow this case closely on social media, when I do see comments mostly forwarded by Laura and others, no surprise there, easily 90% of the JFC comments about the law are simply dead wrong. I get that JFC doesn't care about the truth. I also get that JFC is allowed to claim that I don't know the law. That's why we have courts to settle these disputes. Okay. But here's the deal. JFC wants to fight this battle on social media, not in court. Why, how are they going to go to court with you? Like, what are they supposed to take to court? Okay, all right. And JFC thinks the order today is a win for Clayton. I mean, it does uphold the ruling, so there's that. That's absolutely wrong as a matter of law. First, the order today is void. That means it literally doesn't exist because Mata had no authority to issue this order while the notice of change of judge remains unsolved. Excuse me. And no, the notice has not been denied as of yet. That conclusion is based in part on the text of Family Law Rule 6.1, which explains the procedure once a notice of change of judge is filed. So he's like, yeah, she wasn't supposed to rule that because this other thing wasn't ruled on. We know how much of a hard on he gets for the rules. I get it. Say cheese. Objection, repetitive, David. Oh, that's so funny, especially for you. All right, so it says on filing of the affidavit for cause, the named judge should proceed no further in action except to make such temporary orders as are necessary to prevent immediate and irreparable harm from occurring before the request is decided and the action transferred. However, if the named judge is the only judge in the county, that judge may also perform the functions of the presiding judge. So it's, it's whatever. Got that? Do you guys got that? This shouldn't be that hard to understand. If the judge assigned to your case is biased and unwilling to follow the law, you have a legal right to ask the presiding judge, Mata's boss, to look at the situation and determine if you are entitled to a new judge. Yes, you do have that right, David. Of course you do. But do you have what you need to back it up is the real issue. Lots of people can have rights to do things, but whether or not they can back it up is kind of what's important. While that request is pending, the case is placed on hold. The rule says while the notice is pending, the named judge, Mata, should proceed no further in the action. The only exception is to make temporary orders to prevent irreparable harm. Obviously, that exception doesn't apply here. So, once again, Mata has ignored the rules and done something she had no right to do. Okay. So, what's next? What happens when a judge ignores the law and continues to make rulings in the case after a notice is filed? Well, believe it or not, that does happen sometimes. And the Arizona courts have been clear. Any action taken by the notice judge after the notice is filed in void. It is well settled that when an affidavit of bias and prejudice is timely filed, the judge has no discretion to do anything further in the case except to transfer the case to another division. So if this is void, why are we talking about it anyway? I mean, I don't understand his points here, but it's just because he wants to point out that someone else has done a mistake, never him, because he's a perfect little lawyer angel.
What's your
Be
point,
like,
David?
huzzah! Oh, are you back? Yes, you are back. I see your face now. Sorry, it was covering the face, and last time I looked, you weren't here anymore. So her hair does look amazing, doesn't it? I know. Always.
Y'all know how to gas a girl up. Can I just have y'all follow me around all day and tell me that my hair looks great?
I know, right? Put it on repeat. So then in West v. Superior Court, since he had no jurisdiction to do other than transfer the preliminary injunction proceedings to another judge, the order granting the preliminary injunction was void. Then there's a bank one. In Arizona, like most states, when a judge issues a void order, that order is literally treated as if it doesn't exist. But even if her order is to deny what he wanted, then we go back to the other order, which was Clayton. She sided with Clayton. So doesn't make that decision. That's still what's on the table. But okay. Okay. That order is literally treated as if it doesn't exist. Based on this, today's order denying our request for a new trial is void and thus has zero legal effects. You're still in the same spot you were. But there's also a second problem. Oh, David, what is it? Today's order is not signed. Oh my God, the horror. Oh, how dramatic. So dramatic.
Was oh my God, he parses so much.
Wow. It is what we in Arizona call an unsigned minute entry order. Why does that matter? It matters because in Arizona, and again, virtually every court I've practiced in uses the same rule. Unsigned orders aren't final. Right. Okay. That makes them very different from a signed order. Well, if it's 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 moot, David. It's moot. Here's why.
Moot.
You can only appeal final orders from the court. Again, if you are not a lawyer, this may sound crazy, but while a case is pending, the judge may issue lots of different orders. Orders granting, denying discovery, orders extending deadlines, orders setting hearing dates, orders dismissing parties or claims, orders denying a request to dismiss parties or claims. The list is basically endless. We know. It's the judge. David, thank you for letting us know what they do. Okay. The law, however, is crystal clear, with only a tiny handful of exceptions. Most orders issued in the middle of a case do not qualify as final. Under the rules, to be considered final, an order must terminate the entire case as to all claims, issues, and parties, and the order must be signed by a judge. If anything is left unresolved, or if the order isn't signed, then any order issued by the judge is not considered final. You said it wasn't signed, and then it's why are we arguing this? This is weird. Hi, Nicola. Good morning to you. Happy to see you here today. Oh, don't worry. You haven't missed any Rule 26 stuff today, babe. All right. Oh, and to help make things even more confusing, I'm not confused by any of this, David, but okay. The rules do allow a judge to issue something called a partial final order or a partial final judgment. The post-trial ruling on June 17th, 2024 was a partial final judgment. But to qualify as a partial final judgment order, the decision is required to contain very specific language and findings. Any order that doesn't contain such language is deemed non-final and thus non-appealable. So, what is the point of all of this? What is it, David? What is the point of all of this? Tell us. By the way, what are you drinking today? Buff? I'm trying the peach. Peach is delicious. It tastes like a real
Oh,
peach. Oh my God.
I'm
so
still
good.
drinking the Cosmic Stardust.
Oh.
Okay, I like the aesthetic. It's such a pretty can, though.
It is. It is. It's not as cute as the peach one, to be quite honest. Probably can't even see it, can you? No.
Well, not with the green screen. It kinda
No.
But I'm so picky about my fruit flavors. So
Yeah.
I don't know if I could do peach. I'm so
It tastes like
picky,
real
y'all.
peach, not artificial peach, in my opinion. So you're probably
I'm
gonna hate it.
I'm like a 6-year-old, you know.
You are. Me too. It's okay. We both have weird food things.
I have a 6-year-old palate.
Very true. All right. So, what is the point of all of this? Well, putting aside the fact that it's otherwise void, the order issued today is not signed, nor does it meet the requirements of a partial final judgment. Therefore, even if the order wasn't void, which it is, but can it be void if it's not even signed in the first place? Just saying, if it's not even legit because a signature's there, then voiding it isn't necessary because it's not signed.
Llama.
Ugh.
He passed the bar twice on
Two
his
times.
first try.
2 times. First try.
I don't know why you're questioning him.
Therefore, even if the order wasn't void, which it is, it would almost certainly not be appealable. That means the order is just kind of an odd, meaningless nullity, like this blog post. As a practical matter, it's exactly like this order never existed at all, but we're going to talk about it for a very long time. But again, don't take my word for it. Here's what the Arizona Court of Appeals said in a similar decision issued earlier this month. We lack jurisdiction to consider husband's appeal from the order awarding attorney fees to wife. The second amended notice of appeals list, the signed minute entry dated April 28th, 2023. There is no such signed order. The record includes an unsigned minute entry order dated April 28th, 2023, filed May 1st, 2023. This order does not state the fee award amount, nor does it comply with Rule 78B. Thus, it is not a final appealable order. Okay. Husband also filed a separate notice of appeal when the Superior Court later awarded wife $3,552 in fees and cost in a signed order with Rule 78B language. We dismissed husband's appeal from the attorney's fees judgment, finding entry was improper. As a result, we dismissed the appeal from the order awarding attorney fees to wife for lack of jurisdiction. Okay, got all this straight, folks? Let me just break it down as simply as I can. 1, David. Sorry. I tried. David just cracks me up. He's ridiculous.
Why?
It's like you've already explained it. Now you're trying to explain even more so. Like what? Come on.
Who is he arguing? Does he have an invisible judge in his head that he's arguing his cases? Do you think he argues in front of the mirror?
Yes, I do believe that. I do believe that. Very much so. Nord says, in my head, David is constantly having the vapors clutching his pearls like a proper Victorian lady. Yes, absolutely.
You know what? I think it's someone to do an AI picture of that.
Yes. Yes. Because don't worry, there'll be more pearl clutching for David. He just go away at all. All right. Let me just break it down as simply as I can. 1, the order today is void because it was issued by a judge who is subject to an unresolved notice of change of judge for cause. Because the order is void, it has no legal effect. Okay. 2, the order is unsigned and therefore non-final, which I don't know why that's not the first one. But okay. Why does that matter? It matters for 2 reasons. All right, we're going into A and B here. First, because you can't appeal non-final orders. And second, Laura's time to appeal does not begin running until the court issues a final signed order. That comes straight from Rule 9 of the Arizona Civil Appellate Procedure, which states, 1, if a party timely and properly files with the Superior Court Clerk any of the following motions, the time to file a notice of appeal or cross appeal for all parties begins to run from the entry by the Superior Court Clerk of a signed written order disposing of the last such remaining motion. That's also the same issue discussed in the Constantine case mentioned above. You can't appeal unsigned minute entry orders because they're not final. And they're not signed, but okay. Isn't he though? Isn't he? Isn't he? He really, really is. He's arguing with Grok to his skills. Oh, he's something. 3, because the unsigned order is non-final, Laura's time to appeal has not started running yet. Per Rule 9, Laura has 30 days to appeal from the entry of a signed written order disposing of her post-trial motions. We don't have a signed order yet, so the clock hasn't started ticking. Okay. All right, David. Like virtually everything else in the law, there is a narrow exception that might permit, but not require, Laura to appeal the unsigned order immediately, even though today's order is non-appealable on its face. Whenever he says that, he's like, I did find a loophole. Don't make me use it. Because I feel like that's what he just said there. Don't make me. This post is long enough already. Yes. Yes, it is, David. But you're still only on your 4th bullet point here. So, okay. But if you really want to become an expert on obscure issues of appellate jurisdiction, read this. Barassi v. Madison. Okay. From 1981. Finding premature notice of appeal from non-final order was okay because dismissal of the present appeal would punish the appellate for being too diligent. I don't think this exception applies here because there are too many other unresolved issues hanging out there, such as the notice of change of judge, plus the amount of fees. All else aside, the issue of whether we will get a new judge remains unresolved as of today. The presiding judge may still grant our notice, in which case the matter will be assigned to a new judge, or she may deny the notice, in which case we will immediately appeal. He does have hope, which is interesting. Nicola, 5,000 pages or less, please, Attorney Jean Grace. Well, he did not file a motion to extend pages for his blog post, so I think he's still limited. If Judge Fisk removes Mata from the case, this creates a real procedural mess. because it means the new judge technically won't be able to consider the arguments raised in the post-trial motions to vacate, since those motions have already been denied. I assume that is exactly why Mata issued the decision today, purely to try and block Laura from having a new judge correct the damage caused by the June 17th ruling. Okay. But that plan is doomed to fail because Family Law Rule 85 permits, indeed requires, that void orders be set aside. So let's say in the next 30 days, Judge Fisk comes back, she does, and removes Mata from the case. She doesn't. We will then immediately bring a motion asking the new judge to vacate today's order, denying Laura's post-trial motions, and that will open the door for the new judge to rule on those issues. Again, just like today's order never existed. None of this happens. 7, ultimately, even if Judge Fisk denies our request to disqualify Mata, that basically has zero impact on this case, does it? Because it kind of seems like it's just kibosh, but okay. We would simply appeal that issue along with everything else, and I'm confident the Court of Appeals will not look kindly on what has happened here. Okay. Thus, the Court of Appeals the Court of Appeals could still send this back for a new trial, and that would involve an automatic change of judge as a matter of right under a different rule. All this procedural nonsense aside, there will be a day when all these issues are resolved. Just not in the way you wanted them to be. One way or another, Laura is entitled to her day in court, which she had, in front of a judge who is fair, unbiased, who cares about the rules, and who actually follows those rules. That day hasn't come yet, but it will. And I think that judge is in her criminal case right now. Oh, Dave.
What about the rules about lying on the stand?
What about those rules, huh? That's wild. What about
How do we just keep picking and choosing which rules we follow?
right? Seichi says what is diabolical about this is Gingras certainly knew that chances on appeal were not good, but happily took money from Sarah, Jan, and Ron. Sure did. Sure did. Unless he didn't get, I mean, they don't like paying stuff. So do we even know if he actually got paid? I mean, I think that is exactly where some of the money went. But I agree with you, but we don't know. They don't like paying stuff. Or at least they don't like reporting to the federal government about what they pay for. So he really does like to hear himself think, yes, yes. Do we get to watch the most uncomfortable debate where he tries to defend this motion? Are you talking about the one between him and Rachel? Not yet, because we're still in 2024. And so that happens in 2025, I believe, or somewhere after the Mike Marraccini thing, if I recall, or maybe it's before. But we're not there yet, but we will. I think you're talking about with Reality Steve. So sometimes I wonder if he really just got in his own ego, thought he could schmooze his way through this. I mean, ego's a hell of a drug.
Yes, it is.
Apartment. Oh, that's funny, but I don't know. It was
Allegedly,
mid-2025. Okay.
in my opinion.
I was gonna say, I thought I saw that when we were catching up on the Mike Marraccini story for 2025 before the fundraiser, I thought that debate fell in the timeline, but obviously we didn't have time to cover it. Instead, we go back later. So after living Masita Loca, or do you mean Casita Loca? Either way, hilarious. Hilarious. Love
No,
it.
mesita in front of casita.
Oh, because it's messy.
Casita was a mesita.
Yeah, I don't speak Spanish.
It's not Spanish. I don't
Casita is
think.
not a Spanish word?
No, casita is, but mesita isn't.
Oh, well. Well, okay. Anywho, all right, let's go into our next one. So here he is, tooting his own horn about an unsigned thing that's also void and whatever. And he's like, we'll let Judge Rhonda Fisk decide, and you all will be eating your shoes. All right, because that's how confident I am in being right. Well, spoiler alert. It does not go how he thinks it's going to go. All right, so let's put this up here. And okay. So it's kind of a long one, but I think we're probably going to find joy in this.
And it's
Let me-
probably legally, isn't it?
It is a little legally, so I'll read it, and then you can read the bar stuff, which I don't think has, inappropriate things.
It probably does.
Why can't I scroll? Oh, there's my scroll bar. Sometimes, so because I have multiple screens, not all my screens are the same sizes. So when I go full screen on one and I bring it to the smaller one, it like cuts it off, and I'm just like, where's my bar? All right. So this was, pardon me, filed on August 13th. So a little less than a month after David's blog Into the Void. Why is he the most upset sounding lawyer, though? Yeah. I mean, yeah, I guess I can put the comments on, but it's going to be hard to see, and it's going to be over the thing. So whatever. All right. Just gonna make them small. No, that's too much. That's too much. There we go. That shouldn't get too much in the way, I guess, for you guys. All right. So let's get into this. Now, again, this is Honorable Rhonda Fisk, right? Not Mata, but this is in reference to everything David has filed. This court has considered petitioner Laura Owens' notice of change of judge, all that crap. I'm not going to read it. We already know that. So, pursuant to Rule 6.1, Arizona Rules of Family Law Procedure, the Rule 6.1 motion was referred to the Family Department, presiding Judge Rhonda Fisk, this court for ruling. For the reasons set forth herein, this Rule 6.1 motion is denied. Denied. Quick denied. Okay. Petitioner's Rule 6.1 motion seeks to disqualify for cause the assigned family court judge, Judge Julie Mata, on the basis of bias and prejudice within the meaning of the Arizona Code. See Rule 6.1. Specifically, petitioner alleges that Judge Mata purportedly did the following. 1, performed an independent investigation into the facts of the case, and in so doing, considered and relied upon information posted on the internet about the case. And 2, engaged in ex parte communications regarding this case with her father, who appeared at the trial as a spectator. We'll just go on that. As a threshold to this matter, this court apologizes to the parties for the delay in issuing this ruling. The court had technical difficulties opening the compilation CD, including with the affidavit. I love there's a compilation.
I know, it made me think of like high school, like when you made your like compilation discs and you're like, to my best friend, all of our bestie music, and you handed it out. No, I'm sorry. It just made me.
Yes.
Oh, you made a compilation disc for the judge. That's adorable.
Oh, something. He does, doesn't he? What date is the court date? Hi, Mike. This is from August, what did I say, 13th, I think. So, yes, there you go. Let's see, where were we? When opened with Windows Media Player, the file entitled produced an error message. We can't open Judge Mata's Dad compilation. It uses unsupported encoded settings. With technical assistance, the court finally was able to open and review the compilation CD using VLC Media Player. After reviewing the CD, the court prepared its ruling. Oh, okay. So they got it to work. No, you're fine, Mike. Don't take it that way. I did not mean it that way. Apologize if you did. I'm annoyed by David, by the way. I don't know if you've watched it. Dave, when we read a David blog, it is very hard to put yourself back in reality from some of the things you hear from that man. That man, he's something. So, my apologies if that sounded harsh. It's people are always okay to ask questions here. Not everybody joins at the same exact time, so it's absolutely fine. Timeline of the Rule 6.1 motion. Respondent contends that the Rule 6.1 motion is time barred under the Arizona Code on the basis that it was filed after final trial and final judgment under Rule 78. C responds as 4. The court finds that the analysis as to timelines is more nuanced than respondent suggests. A Rule 6.1 motion for change of judge for cause must be filed within 20 days of discovering the grounds exist for a change of judge. This court must at least consider the factual allegations to determine whether they are time barred. Man, these people fucking love their rules. Love their rules. You'll make a video discussing why this compilation disc was bullshit. This is what you guys sent him that we watched a while ago. That's what he's talking about, right? With like y'all outside the courtroom and all of that. Is that what you're talking about?
I would love to see that, Hellville. No, I mean, like,
Okay,
I
yeah.
would like someone to break it down and like, because we weren't there. Like, I wasn't there for that. Like, so, I mean, we only see what's done.
You absolutely
know.
should do it.
Break it down. I would love to see it.
Let's see. So let's the court must at least consider the factual allegations. All right. So Rule 6.1 motion affidavit alleged as follows that Judge Mata held an evidentiary hearing on June 10th, 2024. Let's see. Judge Mata's dad attended the June 10th hearing as a spectator and spoke to other people in attendance. See affidavit 66 to 67 individuals, Dave Neal and Megan Fox, among others, live streamed and posted on social media various interviews with people who spoke to her dad at the hearing. An accompanying compilation CD. On or about June 17th at 10:10 a.m., Laura's counsel emailed Judge Mata's division and respondents' counsel that the statements made on social media had just come to his attention and warranted a change of judge for cause. All right, let's see what this note is here. So here's the footnote, though, regarding where's the footnote in this? Anyway, that says that the Rule 6.1 motion alleges that these two actions separately violated the rules, that a judge shall not investigate facts in a matter independently. It is not for this court to determine whether Judge Mata has violated the Arizona rules of judicial conduct. Moreover, the Rule 6.1 motion makes vague allegations of violations of petitioner's right to due process under law under both the United States and Arizona constitutions. Again, it is not within this court's purview to determine whether Judge Mata made errors in her findings of facts and or conclusions of law that violated due process and or warrant a new trial. I would think that's the appellate court. Yes, I believe so.
All I have to say is I object to these footnotes being longer than the actual paragraphs themselves.
Oh, at 11:58 a.m., Judge Mata's division sent a response email instructing counsel to file an appropriate motion to bring any issue to the court's attention. On June 18th, 2024, at 8 a.m., Judge Mata's under advisement ruling was filed. The June 17th ruling contained detailed finding of facts, including the following finding: that Dr. Samantha Deans further testified that Planned Parenthood is not open on Sundays. When Laura testified, she sought care July 2nd, 2023. Now, the trial transcript from the June 10th hearing reflects that Dr. Deans did not testify that Planned Parenthood is not open on Sundays. Oh, interesting. Hi, in disguise. Hi, hope you're doing well today. Happy to see you here. Now, based on the foregoing, the court finds that the Rule 6.1 motion was timely filed. In making this finding, the court acknowledges that within 20 days of June 17th is Sunday, July 7th. Given the circumstances of this case, including the fact that petitioner's counsel was on a previously disclosed vacation, the court finds that the filing of the motion on the next business day was timely. Okay. That's okay in disguise. That's okay. You can still hang out anyway. And people are always happy to fill you in. Based on the following, the court finds, I'm sorry, that was what I just read. The affidavit also details various facts and rulings that Laura's counsel alleges constitute a summary of pretrial judicial bias and a summary of judicial misconduct and bias at trial. Okay, so alleging that Judge Mana manifested clear prejudice and or bias early in the proceedings in the form of multiple unexplained adverse rulings. Well, they weren't one sentence, but okay. Don't worry, this one's not too terribly long, guys. Then we get emails for bar complaints, which is fun. Don't worry, fun is coming. The court finds that these events that petitioner contends constitute misconduct. Sorry, let me start that over again. That is where I am, right? Yes. Okay. The court finds that these events that petitioner contends constitute misconduct and bias occurred and were known to the petitioner more than 20 days before she filed her Rule 6.1 motion. The court will limit its evaluation of the Rule 6 motion solely to the two allegations identified in the second paragraph of this ruling. So they're not going to do all the other stuff. Request for hearing. Laura has requested that this court hold a hearing and order subpoenas for Judge Mata and her dad. A presiding judge reviewing a Rule 6 motion for a change of judge as a matter of right has discretion as to whether to hold an evidentiary hearing. The presiding judge may hold a hearing to determine the issues raised in the affidavit or may decide the issues based on any affidavits and memorandum filed by the parties. This court denies Laura's request and will decide the Rule 6.1 motion on the affidavit and memorandum filed by the parties, as well as those on the docket of which this court takes judicial notice. So they're done. She's like, we're not doing a hearing. Okay, this isn't necessary. And this is appeal stuff. Yes, this is in regards to Laura Owens' case, by the way. So yes. They wanted a new trial afterwards because they didn't like what happened. A party seeking a change of judge for cause must establish grounds by affidavit. Rule 6.1. One of the grounds which may be alleged for change of judge is that the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. The sufficiency of any cause belief must be determined by an objective standard, not by reference to the affiant's subjective belief. Now, I mean, it's kind of, judges are given a lot of leeway, and it's kind of hard to prove bias a lot of the times. It's usually pretty blatant. I mean, I know that it can happen. It has happened and does happen, but usually it's like so freaking obvious. This isn't as obvious as David wants to claim that it is, in my opinion. But, sometimes they're like, oh, yeah, there was a few things, but it's not enough to override and get a new trial. Happens in appeals all of the time. So, anyway, this is all case law. We're not going to go. That's fine, Judge. Well, actually, no, we're all here learning today. So in case you don't know, we'll learn together. Case law instructs that in Arizona, a party challenging a trial judge's impartiality must overcome the presumption that trial judges are free of bias and prejudice. Okay. Judicial rulings alone do not support a finding of bias or partiality without a showing of extrajudicial source of bias or a deep-seated favoritism. A change of judge for cause is not warranted if based merely on speculation, suspicion, apprehension, or imagination. Big on the last one. Big on the last one. Instead, the party seeking to notice the judge for cause must prove bias or prejudice by a preponderance of the evidence, which I don't think they have. So basically, like, hey, just because there's something that to you seems biased in this ruling, you're going to have a whole lot of other shit to back it up. She doesn't really have, but anyway. Is this the lady that was faking being pregnant? Or yes, that is, well, we've covered two now, Laura Owens and Taylor Parker, but this one is Laura Owens. Yes. It's really, really interesting and similarities, yes, to the BAM one. I mean, yes and no. If you want to see, or if you want to see what some of us are talking about regarding bricks and minifigs and the civil case, especially about why some of us are saying the things we are about, hey, they can say whatever they want in there. It's going to drag out forever. The Laura Owens case is an excellent example of why you need money when you're up against liars, allegedly, in court regarding BAM. Don't worry, she's facing 14 charges for them for perjury. But it's very interesting because it might come in handy later with BAM. And she is definitely the reason why I tell her, right, they need all their money. All right. Because she took 3 guys to court whose fees were about, at least, I think the last estimate was about $750,000 for all lies and bullshit. And she was just one person with no corporate money. So it's a lot, but it's very, very interesting. Look, it's Friday and I want to work, but about as much as Laura does. Oh, it's something. All right. So where was I? Apologize. Imagination. Instead, the party seeking to notice the judge for cause must prove bias. Or I did that one. For preponderance of evidence. The court will separately consider petitioner's 2 claims of bias and or prejudice. All right. So now she's going to respond to these. Oh, yeah. Great idea. Thank you, Say Cheese. I don't know how I forget, but this case is fascinating. If you are up for a broad overview, listen to the Love Trap podcast. It's very good. If you want to deep dive, and then start with the beginning of our playlist, because we have went through all of the court documents for all the different victims. We covered literally everything from beginning to end. I mean, we're still in 2024 because there's still that much to cover because it's still going on today, as of today. So very interesting case to get into. All right. So allegation of independent investigation by Judge Mata. Let's see what Honorable Judge Fisk has to say about this. So Laura correctly points out that Judge Mata's July 17 ruling contains a factual error. The transcript from the June, well, okay, I'm just going to say, are we talking about, wouldn't this be June 17th if it's what I think it is? Her ruling was June 17th. So here we are again. Just saying. Sure, David will make more about it.
Everybody has issues with dates. Dates are hard.
Right?
And there's so many dates in this case because these people are obnoxiously file things.
Oh, you think you're going to replay the playlist? Yeah, I mean, because even us, like, we do plan on rereading the investigative report, which is what we started with, which is also a very good overview of the case, right? It's what the investigators submitted to the court to get all these felony charges. So that's a great place to start on our list as well. That's what we started with. And then we deep dived. And now when we get back to the investigative report, we're probably going to reread it again, knowing everything we know now, because there's so much in every filing and watching the escalation over time. I think it's going to be a very interesting reread for us.
Yeah.
No.
That was my first introduction to the case, and the just see this, you could see the reactions where it's like, what the fuck?
It's something. So, oh, hold on. My dog wants to go outside. How many fake? Too many. How many faking being pregnant cases are there? Too many, quite frankly. Hold on, let me let Zoe out. Oh, jeez. Okay, all right. I know you don't have to scratch. I'm literally a foot away from you. There you go.
Do you want me to finish or pick up where you left off?
Yeah, if you don't mind, because I'm going to take the opportunity then to do a bathroom break as well.
Okay. So petitioner correctly points out that Judge Mata's July 17th ruling contains a factual error, i.e. the transcript from the June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. Judicial rulings alone almost never constitute a valid basis for bias or partiality motion. This factual error can be corrected through a post-trial motion or appellate proceeding. It does not, standing alone, indicate bias. To demonstrate bias, petitioner asked the court to infer that Judge Mata's erroneous findings constitutes irrefutable evidence. All right, hang on. Let me pull this up on my side because that chat's getting in my way. Okay. And that she performed a secret, undisclosed investigation in the facts of this matter and copied that finding from posts on social media. In support of this position, the affidavit includes snips of a June 10th, 2024 comment on petitioner's counsel's website. Planned Parenthood isn't even open on Sundays in LA. And comment posted by the anonymous Twitter user on June 10th, 2024 at 5:08 p.m. It was a Sunday and all LA Planned Parenthood locations are closed on a Sunday. The court finds petitioner relies on the mere speculation and suspicion when alleging that, oh my gosh, my son just popped in behind me. Son, you can't walk in front of the camera. Oh no. Okay, I'll fix it just a minute. Please don't cry. Here. You're good. Don't cry. It's gonna be okay. Everything is fixable. Sorry. That was baby Buffy. Okay, now I'm all flustered. It's Food Friday. Yeah, my kid just like walked on cam and snuck up right behind me.
Oh, being a mom. The life of being a mom.
I was like, son, you don't have any pants on. You're not even supposed to, you're not supposed to be on the camera.
Oh, it's summertime. I'm going to go be outside with my dog. No, but they're lounging in the sun, so I'm not going to stand there and let them back in. It's a beautiful day here, so they'll scratch at the door soon, I'm sure. So, all right. Where were you? I can go back to reading, or you can if you want.
I'm flustered because I try not to let baby on camera. Anyway.
Yeah.
Yeah, that's the part. The court finds petitioner relies on mere speculation.
Okay. You want me to keep reading then? I know this isn't your favorite stuff.
That's fine. Yeah, you can read.
Okay.
Let me go make sure he's okay.
Yeah, you go see everything, and I get it. So the court finds petitioner relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and therefore is biased. The record evidence reflects conflicting testimony about the day, date, and location that petitioner obtained an ultrasound, admitted as Exhibit B28, which Laura admitted to altering. Laura testified that when she was in California on a weekend, she had an ultrasound done under a fake name at a Planned Parenthood. Before trial, Laura had provided a declaration stating that the ultrasound occurred on June 2nd, 2023. At trial, she changed her testimony to say it was an unspecified weekend in late June 2023. Laura further testified that she had altered the ultrasound to reflect the incorrect date of July 7, 2023, and the incorrect provider, Smile, instead of Planned Parenthood. So, Okay. Dr. Deans testified that she had reviewed the altered ultrasound and available medical records to prepare a report. Dr. Deans expressed concern about the legitimacy of petitioner's medical records. Dr. Deans confirmed the Planned Parenthood's national guidelines requiring identification at the time of visit to confirm the identity of a patient. The patient can't be seen anonymously. Dr. Dean's testimony did not address which days of the week the Planned Parenthood offices were open. Based on the foregoing, the court finds that when determined by an objective standard, not by reference to the affiant's subjective belief, petitioner has failed to show by a preponderance of evidence that Judge Motta's finding that Planned Parenthood is not open on Sundays reflects bias or prejudice against Laura. Moreover, although not dispositive of the issue, the court further finds that this singular factual finding is of little to no importance given the rest of the findings in the July 17th ruling. Exactly, like your client sat up there and lied a bazillion times. I mean, come on. Let's see. No pants on is the great life. Yeah, protect the babies. Can you cut that? Oh yeah. Yeah, she probably will go in and do that. I mean, that's why I have a giant green screen because I don't want my kid to be on there as well. But it happens. But yeah, no, you can always go back and clip out parts, and she'll probably do that because when we were covering the Devin Michaels trial last year, in the defense's opening statements, they put up a very sexy time photo of her husband slash stepson. It's a very complicated story with a raging boner. It's impressive. But we're all just like, what? What is happening? Why is this part of their opening statements? And so then we went back in and like blurted it all out so YouTube didn't hate us because you can't be having that on YouTube. It really was not necessary for their case, but it was definitely a surprise. Uh, let's see. Yeah, she'll blur him out. It's no big deal. Godfather. Objection, you shouldn't have been able to discover my perjury. It's rude and it's embarrassing. Why are they trying to humiliate Llama like that? Finally hear from it really did happen. It was something. And I think it's as in typical Llama fashion. I step away to go to the bathroom, and it was just me on for that trial. And as I come back, like, I'm just like, oh my God, what happened? Or maybe I just come back. I don't know what it was. It was a whole thing. Oh, he had it because his sunglasses broke. Oh, poor little Bubby. Poor little Bubby. Buffy. That's what I like to call him. Oh, he'll be okay. He'll be okay. Lots of mom hugs. You got to figure out how to get chat on top like that too. Oh, so when you're on the comments tab, I'll just let you know. At the top, there's a little toggle that says show comments on stage, and then some bars, and you can change how big or small, wide, tall, all that jazz. So, all right, back to this though. Allegations of improper ex parte communication with Motta's dad. Laura alleges that Judge Motta's father was present in the overflow room during the trial and spoke with several. And Zoe scratches at the door. Of course. Of course. See, we all have lives, real lives outside of the internet. Where's the other dog? All right. I don't know where the other dog is. She'll find her way. Okay. All right. Where was I? All right. Laura's counsel admits that the mere fact Judge Motta's father attended the trial, if true, is not the primary concern. For purpose, and also, I mean, if he was like he wasn't even in her actual room. He was in the overflow room. Like, maybe if he was sitting there where they had to make like eye contact, even then it doesn't matter to me. People have come in to watch and have lunch with him afterwards. It's not that weird, but streaming is dynamic, y'all. It sure is, right? She has a silly little bagel. Is that my other dog? I don't know. All right. So, for purposes of deciding the Rule 6.1 motion, this court accepts these allegations as true and finds that if they occurred, was not improper for Judge Mata's father to attend a public trial as a spectator and speak to other courtroom observers. Exactly. He is like a civilian. He can kind of say whatever he wants, but okay. Laura asked this court to infer that various statements made by courtroom observers about Mata's dad confirmed that Judge Mata was biased or prejudiced against Laura. Laura's counsel acknowledges that his personal view, based on the past several months, is that Clayton's followers are generally not honest or reliable. Nevertheless, Laura's counsel asked this court to find that an edited compilation of these individuals' comments about Judge Mata's father are clear extrajudicial evidence showing that Judge Mata had a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. If only she'd go to Topgolf with Laura, it would be fine. Applying an objective standard, not by reference to the affiant's subjective belief, Rule 6.1, the court carefully reviewed the compilation CD and considered in context each of the comments identified in Laura's counsel's affidavit. Given the seriousness of the allegations, the court has made best efforts to provide both the context and verbatim language of the various statements. Though, admittedly, the audio of the compilation CD is very difficult to understand at times. All right, hold on. Zoe's scratching on one side of the door to let me know that Kita is out there, even though Zoe's deaf, but okay, she knows. So just a second. I know, Zoe. Oh, wait, she's not even there. See, she's out there laying in the sun. Oh, you just wanted back outside. Oh, okay. All right, you girls sunbathe. Get your summer tans on, girls. It's fine. Okay. Excuse me. It's a nice day with dogs, right? Oh well, that's fine. I don't care if my lighting looks good or not. Don't care. So is she trying to get the judge kicked because her followers said he's a bad dude? No. So she's trying to get a new judge because the judge's dad was in a courtroom and people saying that he said it was like I don't want to misstate his words and get him confused, but that it was a circus of a case or something. It's stupid for one. Two, as Hellville says, it's hearsay and out of context. But David's just like her dad was there, and because he was there, it influenced her decision because she loves her dad, I guess. I don't know. It's so stupid. It's a very stupid argument. They're having a legal tantrum of hearsay, right? Yeah, that Judge Mata only convicted Laura because her dad, Judge Mata's Julie Mata, was there and wanted to impress him. Yes, that is David's argument about that, which is stupid. It's very, very stupid. Hellville, who was there, said her dad, if he really was there, was in the overflow room, not the courtroom. Yeah, also, in my opinion. Yeah, it's a public. He can go if he wants, but okay. No, no, no. Not at all. And even if you think you lost the plot, it's because it doesn't make any sense, Mary. That's why. All right. So then statements by Hava Darby. Okay. I don't know who Hava Darby is. But okay. Petitioner Laura alleges that Ms. Derby, who speaks between 0 to 40 seconds in the compilation CD, also made statements which appear to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. The first video clip on the compilation CD depicts a virtual meeting here among 9 participants with screen names, including one woman with the screen name Hava Derby. Ms. Derby holds up her phone and makes the following statement. I ran into Judge Mata's dad in the parking lot afterwards, and I asked him, like, well, what did you think? He was like, I got to show you something. A female voice says, what? So he whips out these papers in his hand, and did anybody, I haven't been online really today, but did anybody, I saw kind of briefly that it was denied. This request for findings of facts and conclusions of law proposed findings, the male voice, that wasn't denied. That was not denied. Okay. So anyway, did anybody get a copy of this? He was saying, Julie told me this is just you, Dad, you got to read this, and printed out a copy. Again, it's hearsay. Bunch of people putting words in other people's mouths. I don't think that part actually was accurate, or maybe there's lots of possibilities of what could have actually been said, or how somebody interprets something. So the plot is not a straight line. No, it's not a straight line, and it's made with jumbo crowns. He had a point that she didn't have facts and evidence about Planned Parenthood being closed on Sunday. Didn't matter how much she lied about going to Planned Parenthood and Mission Viejo, and didn't produce records. Right. Also, I heard that Mata's dad was a lawyer. So, like, also his opinion to be like, well, yeah, probably not going to rule in Clayton's favor, based on what I saw. I mean, how is that any different? If that's what happened, how is that any different? But the paperwork, all of that, I don't believe that for 1 second. Stop. How does Ms. Darby remember all of this? Well, I don't know. Who knows? I don't know. But that's not really enough. But okay. For purposes of deciding the rule, I mean, maybe it did happen. I don't know. I wasn't there. I'm just saying I'm not surprised the court isn't like, this is hearsay. This means nothing, but okay. All right. So for purposes of deciding the Rule 6.1 motion, this court accepts that the scenario recounted by Ms. Darby might have occurred, though Ms. Darby appears not to be clear as to exactly what she is talking about. Oh my goodness, Zoe. For Pete's sake, decide. Are we going inside, outside? What are we doing? What are we doing today? Okay. All right, fine. Come on. You too, Kita. Come on, you too. I know you're fine out here, but she's going to be worried and annoyed about you not being around, even though she's annoyed and worried when you are around. But okay. Pets. We love our pets and their weird personalities. Sorry, here, I'll tangle that in here. Okay. This court finds that the fact that a trial judge might have told a family member that she was presiding over a case, and might have provided a copy of publicly available filing, e.g., the request for findings of facts and conclusions of law and proposed filings, which was filed on June 3rd, 7 days before, neither proves by a preponderance of the evidence that the judge was biased or prejudiced, nor proves that she told her family member how she intended to rule before the case was tried. Again, all this stuff was very public. Her dad, also apparently a former lawyer, like, just nonsense. Yeah. Even if she knew, she can't consider it unless she takes judicial notice of it, right? This person was relentlessly villainized by the meanies online because Gingras distorted and lied about this interaction. I mean, I don't know. It doesn't matter to me in the in the grand scheme of things, it wouldn't have been enough anyway to overrule things. As the judge just said, there's not much. 2, statements of Dave Neal and individuals speaking with him. Oh. Laura's counsel's affidavit further alleges that an individual named Dave Neal made remarks to signal to the person speaking that they should not disclose further information regarding the comments they claim to have received from Judge Mata's father because her believed they would expose judicial misconduct and bias on Judge Mata's part, requiring a new trial if those facts were exposed. That's a quote from the affidavit. That's not what she's saying. That's what David is saying. Now, the second video clip on the compilation CD depicts a group of people standing under an awning. The bottom left corner of the screen says Dave Neal, Rush Hour Podcast. In the foreground, there are 2 men talking, one in a red shirt and the other in a hat, identified in the affidavit as Dave Neal. While the 2 men were talking, a woman in a hat approaches and joins their conversation. A woman on the left in a black shirt chimes in, and a second woman on the right in a black shirt follows up. The male in the red shirt says, Judge Mata's dad was in the court with us. And Dave Neal, man in hat, Judge Mata's dad? No way. It's in the court in the side room where we were. Judge Mata's dad was sitting there. She did fantastic. A woman in hat interjects. I said, Harry, that's really nice. You want to be here to support your daughter. He said, oh, no. I've been hearing about this. I'm here for the circus. The group laughs as the woman in hat walks away. That's okay. Dave then says, hold on. We don't need a mistrial. Additional group laughter because it's a joke. Because he's a fucking comedian. Like, okay. Male in red shirt. We could get him some scones. Yes, scones, says David. Then 10 seconds of the video deleted per podcast stamp. Woman on left. I was waiting to get in. Dave, we just heard. Woman on left. You don't look like the demographic. How did you hear about this case? Inaudible. My daughter. There you go. Hey, that's and he was reading case files. I'm sure he was. I mean, he was probably a judge. I feel like it runs in the family. And it's all public and a very big deal. Woman on right, inaudible. He did not tell me any information about her thoughts. See? Female voice. Yes, Judge Mata's dad. And I was sitting right next to him. Dave Neal says, oh, I'm sure. Yeah. See? Not what David wanted to make everyone believe that conversation was, right? Didn't seem like much to me at all. And again, he's allowed to fucking be there. Just like all of us are allowed to be there. So come on, David. He was just looking for something. He's a comedian. It was a joke. It was so obvious. The third one was, so you're are you women on left or women on right? Or the one in the hat? Oh, you're probably the one in the hat, aren't you? There was a woman in the hat. But anyway, her dad's not dumb enough to try to ruin this whole case. Come on. Anyway, again, for purposes of deciding the Rule 6.1 motion, this court accepts that certain facts recounted by these courtroom observers might have occurred. Mr. Matadad might have informed an observer before the hearing that he heard about the case from Judge Mata. However, Matadad might have told an observer he considered the hearing and additional goings on to be a circus. No, Zoe, you are not going outside again, are you? No, lay down on your little blankets. No, we're not today, ma'am, not today. And Mr. Matadad might have been reviewing paperwork related to the case. When viewed by an objective standard, Matadad alleged statements and actions do not provide proof by a preponderance of the evidence that Judge Mata was biased or prejudiced, or that she told her family member how she intended to rule before the case was tried. All right, I guess Zoe's.
I'll keep
So
going.
then I was like, yeah, here I go. Here, let me scroll up a little bit. Just there you go.
This court also finds that certain statements made by the courtroom observers reflected nothing more than mere conjecture. Like Mr. Neal's statement that Judge Daddy was probably a judge. I feel like it runs in the family. The court further finds that the video reflects that Mr. Neal's remark, "We don't need a mistrial," after the speaker started walking away, was made in jest, as evidenced by his and the onlookers' laughter and his agreement with another bystander that they should get him a scone. The court concurs with the petitioner's counsel's subjective belief that respondent supporters gleefully celebrated Judge Mata's father's attendance at the hearing. See Rule 6.1 motion at 12. And that the supporters' actions, and perhaps even Mr. Howe's alleged actions, can be perceived to have made a mockery of these proceedings. This court declines, however, to impute bias or prejudice to Judge Mata based on the statements made by respondent supporters, whom petitioner's counsel characterizes as generally not honest. All right, let me move over to mine.
Hold on, I'm coming.
No, you're good.
They're just outside fucking around, sniffing a bush. Glad it was such an emergency. Zoe. She didn't go outside to go to the bathroom. She just wants to sniff
It's
at a
almost
bush.
over. Not honest or reliable. Affidavit 73, paragraph 73, about Judge Mata's father, or even statements made by Judge Mata's father himself. It is ordered denying petitioner's motion for change of judge for cause. It is further ordered denying respondent's request for leave to file a supplemental affidavit of attorney's fees and costs. It is further ordered denying respondent's request for this court to enter further orders pursuant to Rule 8.2 of the Arizona Rules of Professional Conduct. And it is further ordered returning this matter to Judge Mata to rule on all pending post-trial motions.
Okay. So that didn't help David out at all. Denied.
Denied.
The bush needed an investigation, right? That's weird. I don't know why they're obsessed with that bush today, but okay. Yeah, this did not work out in Laura and David's, thing, their arguments. So, all right. Oh, but man, we are going to be able to do this other part. Good. Okay, so next we are still in August 14th, 2024. So the next day, this information comes out, and I think these are these out of order or are they in order? Because it's a bunch of emails, you know how they are. It's probably top down, isn't it?
I'm scrolling through looking because I guess I should have done that before.
8:46 a.m. When's the time of the other one? Oh yeah, it's bottom top. Okay. All right. So apparently there was some bar complaints. So let's get into those real quick. This part isn't going to take too terribly long. So on Wednesday, August 7th, Jackie sends this to David from the Arizona bar. Good morning. Attached is a letter from Senior Bar Counsel James Lee regarding the above referenced matter. Also attached is a protective order. Oh, wait, hold on. This is the wrong one. I'm a dingus. Yep. That's the supplement one. Hold on. August 7th. They're only going to 10 on this one.
I was about to say, I don't see what you're reading, and I think that's all in order.
Yeah, I think so too. 30 pages, read 1 through 13. Okay. So I was just clicking on the wrong one. But the next one is bottom top. So there's that. Okay. So let's see what this is about. All right. So this is from, am I showing the right thing? Okay. From David, sent to Jackie, Wednesday, August 7th at 5:58 p.m. Ms. Oh, so y'all, anybody want to adopt a geriatric beagle who doesn't listen ever?
Okay.
Can't
So you
decide?
want me to start it?
Sure, girl, you go right ahead.
Your dog is as bad as my kids.
Oh my goodness.
Okay. This is from Jackie Brokaw, carbon copy to Laura Owens.
Water?
And it's sent, it's from David to Jackie, CC'd, and Laura Owens. Who is that?
She's
Miss
from the bar.
Brokaw. Okay. Attached is my response to the charge from redacted. As before, I have CC'd my client, Laura Owens, on this response since the allegations relate to her case. Although Miss Owens' consent is not required here, she has nevertheless reviewed this response and has given her prior informed written consent to its contents. As I indicated in my other response sent earlier today, Ms. Owens is happy to discuss this matter with bar counsel and to provide any additional information you/he may need. Laura's phone number is, and she is also easy to reach via the email address CC'd here. Laura has read the charge from blank and is familiar with both the complaint and the details in my response. Per ER 4.2, I don't believe bar counsel needs my consent to communicate directly with Laura. I assume such contact is otherwise authorized by law. If my consent is required, please accept this as my consent to communicate. I would assume so, since you're the one doing the emailing. As my consent to communicate directly with Laura. This consent applies to both this charge and also 24-1826 Deans and any other matter involving my representation of Laura. Thanks, David Gingras, Esquire.
All right. I put Zoe up on our bed. She can't get up there herself, so it should be her nap time, even though she just woke up and chose violence today, but that's okay. Oh no, she'll just scratch and scratch and scratch, but that's she's something. I love her, but she's something. All right. So then we have this good morning from Jackie. Oh, this was preceding this. Sorry. Attached is a letter from Senior Bar Counsel James Lee regarding the above referenced matter. Also attached is a protective order that was issued in this matter. So let's read what this says. So this is Gingras's letter to James D. Esquire, the Senior Bar Counsel. Dear Mr. Lee, this is from David, yes? Yes, because his heading's at the top. This letter is in response to yours dated August 7th, 2024, regarding a complaint you received from redacted. As explained below, the complaint has no basis whatsoever and it should be promptly dismissed. After reviewing the charge from redacted, I need to be honest. Her allegations are largely, if not completely, unintelligible. Oh, so it's a she. I wonder which one it is.
It's funny because Jack did tell us when somebody says, I need to be honest.
Mhm.
Well, at least he told me that I need to unpack that.
You took lots of Jack notes. You sure did. Her allegations are largely, if not completely, unintelligible. I have no idea who this person is. I have never met redacted, so I have no personal knowledge regarding her allegations except to the extent they are described in the charge you received. Having said that, I will do my best to decipher her allegations and respond as best as I can. I think I might know who this could be, but I don't know for sure, so I don't want to say. Because the charge contains multiple repetitive statements. Oh, for fuck's sake, David, have you met you? I just read a whole blog post that was you doing literally that. But
I was like,
okay.
what did I do? You said, oh, for fuck's sake.
which appear to raise the same general points. May I point you to Exhibit D, your blog? I will try to lump these together and respond to each group in turn. To help provide some context, as I explained in my response to the charge from Dr. Deans, I represent a woman named Laura Owens with respect to a single case, Owens v. Echard. That matter involved a petition to establish paternity filed by Laura Pro Se on August 1st, blah, 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 where she claimed she had a one-night stand, yada, yada. We don't need to go over that. Laura claims she had a miscarriage in mid-October or early November 2023. Now, if we're back to that date, okay. As a result, how are we back to that date? Oh, that date doesn't work for your client, and you're using it again. Result, she filed a motion to dismiss the paternity action with prejudice on December 28th. Confusingly, the Superior Court granted the motion to dismiss, but then allowed the case to proceed to trial on June 10th, 2024. The trial was supposedly focused on Clayton's request for sanctions based on his allegation that Laura faked being pregnant. Obviously, Laura strenuously denies that she ever faked being pregnant. Wonder why? Is it because the judge thought she was going to reach out to the DA? Maybe. I first appeared in Laura's paternity case on March 25th, 2024. Prior to this, I had no involvement of any kind in the dispute. Also, Laura was represented by other counsel in the paternity case for part of December 2023 through mid-March 2024. Importantly, Laura also had a separate matter involving Mr. Echard. The other matter was not a paternity case. This other proceeding involved a pro se petition for an order of protection. In short, in the OOP case, Laura claimed Clayton harassed her by posting an embarrassing, partially nude, what? Girl, no. Photo of her on the internet. That makes it sound like it's some fucking sexy time picture. After a hearing in late 2023, at which Laura was represented by other counsel, not me, it was before his time, guys, the court found her in favor and granted the protective order against Clayton. After the OOP case ended on March 26, 2024, Clayton's attorney filed a motion to end the OOP case requesting relief from the order based on fraud. In short, Clayton's attorney claimed Laura was never pregnant and thus ineligible for a protective order, which generally requires a prior parental or romantic relationship between the parties. To help respond to that issue, I entered my appearance in the OOP case on April 9th, 2024. However, the OOP case was later consolidated with the paternity case, so I filed nothing further in the OOP case after my initial appearance. Okay, can't wait to see him go on and on and on about this, but not repetitive. David would never. He would never. Turning to the specific claims and Redacted's complaint, she appears primarily focused on the paternity case between Laura and Clayton. Based on her language, it is clear she is a member of the JFC cult, which I previously described. Her complaint is essentially nothing but a copy-pasted list of JFC cult talking points, which have been shared online by other cult members. In case this isn't obvious, the JFC cult sees me as a threat to their goal of obtaining justice for Clayton. So these complaints are presented solely for the purpose of harassing me and trying to interfere with my representation of Laura. Having said that, to the extent I can understand redacted claims, here is my response to each point. 1. Releasing sealed documents. Redacted makes several references suggesting I somehow violated a court order by publishing sealed or confidential information. Here are a few general examples quoted from her charge, all of which are completely conclusory and unsupported. Violating the rules of releasing sealed documents without court permission. Releasing sealed documents without court permission. Oh, is this pertaining to one, Clayton's depositions? The little clips they released of those? And something, her medical records of some kind, right? Is that what these accusations are about? Because the judge said no more releasing things to the public. And then he was like, this is before my time. Breaching confidentiality and contempt of court by unauthorized release of sealed documents, instances of releasing sealed photos, medical records, and videos on social media. A video depicting Clayton Echard's deposition, oh, there we go, which was sealed in the Owens v. Echard case, was allegedly made public before the trial scheduled for June 10th, 2024, emphasis added. As I previously explained in my response to the charge from Dr. Deans, there is no court order sealing anything or otherwise preventing the disclosure of pleadings, transcripts, depositions, or records filed in the case. This is a popular JFC talking point, but it is completely false. Okay, if that's the case, then why didn't you drop Laura's deposition? Just wondering. Just wondering. So and there won't be a ruckus if that happens. Is that what you're saying? No, it's not how it works. On the contrary, and as I previously explained, while Laura was representing herself pro se, she filed a motion on September 14th, 2023, asking the court to seal the entire record. That request was denied by minute entry order dated October 18th, 2023. Okay. After Laura retained counsel, the one before me, her attorney re-raised the same privacy arguments in a motion entitled Motion for Confidentiality and Preliminary Protective Order, filed on January 17th, 2024. A copy of this motion is attached as Exhibit A. That motion expressly asks for an order allowing depositions and other discovery-related materials to be marked confidential and protected from public disclosure. That is true. On February 15th, the court issued an order denying this request in its entirety. A copy of that order is attached as Exhibit B. But she said it in the hearing, I do believe, which this predates the February 21st hearing, if I recall. So, oh, thanks, Mary. Another Mary. There's so many Marys. I love it. Yes, there was a court order about not releasing further medical records, and David continued to discuss them online. Yeah, I'm pretty sure that was said so in that February 21st hearing, but let's see what David has to say. Remember, rules for David, not for me with all this side of people. Aside from these two separate motions filed by Laura asking the court to seal the record and allow parties to keep discovery materials confidential, both of which were denied, Clayton never asked the court for similar relief. He never moved for, nor did the court ever grant any order restricting the publication of depositions or any other case-related documents. There simply is nothing in the docket that would even remotely support such a conclusion. Bearing in mind, even if such an order existed, which it does not, the Arizona Supreme Court has previously determined a trial court cannot lawfully prohibit the publication of matters occurring in open court. Any such order is void. Is a deposition considered open court, though? Because I don't think it is. Because unless we're allowed to go sit in on depositions, which we're not. But is it considered open court? I need to know.
No,
Say
I
cheese.
don't think so.
What's your thoughts,
I wouldn't
babe?
think.
I wouldn't think so either.
I wouldn't think it's considered open court.
This probably explains why the trial court repeatedly denied Laura's request for confidentiality privacy, and why the court specifically rejected her request to keep deposition transcripts confidential. This included medical names, info, all that she said she would not be shared publicly. Yes, we definitely saw those, didn't we? In fairness, there is a single sentence buried in a minute entry order issued in February 2024, before I appeared in the case. Oh, David.
Oh,
David, you fool. Which seems to reflect some sort of informal agreement between the parties not to publish medical records disclosed by the other party. But in this instance, Clayton never disclosed any medical records of any kind. The only medical records at issue in the case belonged to Laura, and she chose to publish them to respond to false statements made by the JFC cult, Clayton, and or his lawyers. I mean, all right, let's release the depositions. Let's release them. Why not? Fuck it.
I'm here for it.
You were distracted with talking to Terry about her legal thing. Yeah, so back since you just missed it, it's not that far back up, but he's arguing because he's being accused of putting the depositions online, medical records, blah 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 blah. And his argument is that the judge did not approve of the motion to seal things. Of course, twice that was denied. But then his statement is that there was no order prohibiting disclosure of details of the court hearing, violated Arizona Constitution, and was void. Superior Court has no authority to foreclose the right of the people and the press from freely discussing and printing the proceedings held in open court. This is regards to the deposition, but depositions, are they technically considered open court? I don't think they are, but you would know better than I do because the public can't just go to a deposition and there's not a judge there, right? So he's trying to say, well, I can. It was all in open court, but I don't know if they're considered that or not. Also, yeah, I don't think they are. A reasonable person wouldn't assume they are, right? If so, I guess I'll start showing up to the deposition. There's a lot of the Karen Reed ones I want to attend. Be like, excuse me, David Gingras Esquire said that this was open court. So, and he's never wrong about anything. So I am here to listen to all of your guys' depositions. All right. So next is witness tampering, threatening to have witnesses arrested. This is another popular JFC cult talking point. They claim I committed witness tampering because I threatened to have a witness arrested. Here is what actually happened. During the course of discovery, Clayton disclosed that he intended to call a trial witness named Mike Marraccini. Mr. Marraccini is an ex-boyfriend of Laura who resides in San Francisco. Laura dated Mr. Marraccini for approximately 2 years in 2016-17. The entirety of Clayton's disclosures regarding Mr. Marraccini are shown here. Is he going to say he didn't try to get him arrested or threaten to? Because he did both. He did both. We already went over it. But okay. As I would in any case, while preparing the case for trial, I reached out to the contact person listed for Mr. Marraccini, a lawyer named Randy Sue Pollock, to ask if I could interview Mr. Marraccini to learn more about his expected testimony. After speaking with Ms. Pollock, she told me she had never heard of the Owens v. Echard case and that she did not believe Mr. Marraccini would appear at trial. I asked Ms. Pollock to confirm this to me in writing. On April 19th, 2024, she did in the email below, saying that her client's not testifying. And okay. A few weeks later, just days before the discovery cutoff, Clayton's counsel informed me that, in fact, contrary to Ms. Pollock's written representation to me, Mr. Marraccini would appear and testify at the trial. In response, I explained there were several problems with this. First, Clayton had failed to disclose anything about the expected substance of Mr. Marraccini's testimony. Second, I noted Laura had a current valid DVRO issued against Mr. Marraccini by the San Francisco County Superior Court, there it is, and that this order did not contain any exception for in-person testimony. Third, I explained under the federal law, it would be a serious federal crime, blah, 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 blah. Guess what? Nothing happened. Nobody arrested Mike because they're all like, you are fucking nuts. And no. The answer is no. So let's get that. Despite raising those concerns, I told Mr. Woodnick I would be happy to work with him to obtain permission from the California court that issued the DVRO so that Mr. Marraccini could testify. I am currently also licensed to practice in California. Just in case you didn't know, I have 2 licenses. I passed the test 2 times. The only condition was I asked Mr. Woodnick to comply with his disclosure obligations by providing me with information regarding Mr. Marraccini's anticipated trial testimony, and Mr. Woodnick rejected that request, leaving us at an impasse. After I was unable to reach any agreement with Mr. Woodnick, I filed an emergency request for a hearing with the trial court so these issues could be discussed. That request was denied without explanation. In order to preserve the issues, on June 3rd, I filed a pretrial statement in which these same issues were discussed. In the pretrial statement, I explained it would be a criminal crime for Mr. Marraccini to violate the California DVRO, and that any violation of the order would subject him to arrest. It didn't, though. It didn't. There is absolutely nothing unethical or inappropriate about any part of these remarks. As the California DVRO order states, the order complies with VAWA and is subjected to automatic mandatory enforcement in all 50 states. The order further contains exactly the same warning that redacted points to as alleged witness tampering. It notes Mr. Marraccini is subject to arrest for any violation of the order, and interstate travel for the purpose of violating the order may result in him being charged with a federal crime. Clearly, there is nothing improper about me providing the same warning to Mr. Marraccini or his counsel that the DVRO itself contains. I mean, dude, if it's because somebody's being subpoenaed to court, nobody gives a shit. All right? It's ridiculous. 3, posted a video of his client lifting her dress above her boobs. What was that? I haven't seen that. That one must have gotten taken down or something. Redacted charge. Sorry, my voice is getting tired. You might have to start reading, Buff, if that's okay. My voice is getting tickly.
Yeah. Sorry, I had to scroll down. Okay.
Are you have your own
Redacted
thing up or mine?
Yeah, I have it up.
Okay.
Charge contains several vague comments about information. I posted about this case, including certain identified photos / videos. Redacted claims one such video purportedly showed his client, Laura Owens, in a manner that may be deemed inappropriate for public disclosure. She further explains Jingers posted a video of his client lifting her dress above her boobs, showing her blue bra and black panty line. Y'all, this is like in all caps. Why are we yelling? What on earth is blank talking about? And why on earth would any sane lawyer post a video of his client lifting her dress above her boobs?
Yeah, I don't
Here's
know
why.
what this video is. I don't think
I
we've
don't
seen
think we
it.
got to see it. Here's why. Because on January 3rd, 2024, Clayton's counsel, Mr. Woodnick, filed a motion for sanctions in the paternity case. In that pleading, which he later withdrew, but not before the JFC cult seized on it, Mr. Woodnick accused Laura of appearing in court wearing a fake moon bump to falsely make it appear she was pregnant. Mr. Woodnick claimed this happened during a videotaped court appearance that took place on November 2nd, 2023. Again, before I was Laura's counsel. Hey, I saw that video. Yes, that is an astonishing. He is so shocked. Astonishing allegation to make, but Mr. Woodnick made it, as shown below.
Thank
To
you.
save
Marcy.
space, the entire 18-page motion for sanctions is not attached as an exhibit. Thank you. Thank you.
Doop, doop.
As it turns out, Mr. Woodnick's moon bump story was completely false. He simply
What?
lied to the court about this point in an effort to make Laura appear crazy. Only a crazy person would wear a fake belly in court.
Oh,
I would.
you're
And,
right.
like, he does like kind of throw her under the bus sometimes. It's like, yeah, David,
The call's coming
Yeah.
from inside the house, David.
It's like,
Jesus Christ.
you're almost there. You're almost there, David. You're almost there.
Mhm.
Oh, God. Oh, sorry. Okay, I'm going back to it. I would have reported this false statement by Mr. Woodnick to the state bar as a clear violation of 3.3. But I understand the bar has unwritten policy against considering complaints filed by lawyers in pending litigation. In any case, this cruel gambit unfortunately worked exactly as Mr. Woodnick intended. We needed some like horror music playing in the background.
Right.
The JFC cult seized on the story and repeatedly spread Mr. Woodnick's moon bump claim far and wide.
We have
And
eyeballs.
not,
We saw it.
I saw it, and I'm just here to say, I'm pretty. You think people were really dumb? You do that. We don't believe our eyes. Okay, sir. An anonymous cult member even created a new Twitter account mocking Laura, showing a photo of her crying while being dragged away by police and suggesting lock her up. Note the link justiceforclayton.com in the account bio. Also, note that the Moon Bump Twitter account has tweeted 980 times about this case.
Shout out to the moon bump.
Right.
I've seen her around for a while, actually. But shout out moon bump. You did it, girl.
As the old saying goes, a lie can travel halfway around the world while the truth is still putting on its shoes. In this instance, that is exactly what happened after Laura hired me. And after suffering months of damage caused by Mr. Woodnick's cruel and patently false moon bump stories being spread online, Laura asked me to help stop the damage.
Ugh, what a
To
hero.
do this, Laura asked me to publish a video she took of herself 24 hours after the court appearance in which she allegedly wore a fake belly. This video clearly showed any allegation of her wearing a moon belly was completely false because her swollen belly was clearly real. The tweet where this video was posted is shown here. Okay, that does not look anything like what she showed in that video. I am sorry that you need to poop, but that is not what that that bump looked like in the video, and I saw it. So I'm just here to say
it's still way too small. Okay, for the end of
and it doesn't
October
look
with
hard.
twins.
She's too thin for me to believe. I know that. Look, I was a really big girl. So my belly was not hard for a while. So I had the fat on top of the baby, right? She's a petite girl.
Yeah.
You can't convince me that there's no, that belly is poop.
That belly is poop. No, I was a petite girl when I was pregnant. And guess what? Like, yeah, it doesn't look like that to me. Also, the moon bump, right? Because that's
Was
exactly
higher.
what the fuck it was higher. Exactly. It was up to her boobs. All right. Look at where the bump is there. Do you see that? It doesn't go up and down, up and down. Like, that's not really what happens. But yeah, remember her moon bump was very defined, very close.
I know. It kept climbing higher and higher to get into the camera.
Which is not how gravity works. Also, not how that works either.
I mean, damn, if I could just pick it up and take it off my bladder, I would have done that too.
Is it Photoshop? Yeah, I think Dave and them like broke it down or something.
Yeah, well, her head looks disproportionately large. It looks like a really shitty Photoshop.
It sure does. Yeah, right. I could do it right now too. Like, you just push out on your stomach.
That's what I'm saying, man. After a pizza, after a few breadsticks, and just not pooping.
It's crazy.
Yeah.
And that,
All
and
right,
they just said that was from the same day.
right. It's
So,
not even, yeah, it should look very similar. I mean, I
yeah,
know babies can change position, and sometimes I will like not be as protrusion, like, my baby would bury a little bit. So one day I would look bigger than I did before, but like not that big of a difference that
not that
somebody
big a
could look at
difference.
you and tell. Like I could tell.
And not
I'm
with
like, oh, you're
twins. Like,
no, not with twins. I've never
no,
had twins, but I would assume there's very few, there's not a whole lot of room.
right? Show the metadata, David.
Oh, he can't because it's a Photoshop and that would give it away. Okay. Again, this video was posted with Laura's written consent and at her request. So this is not an ER 1.6 issue. While this sort of thing may seem very strange in any other context, in this situation, I believed it was necessary and appropriate given the vast amount of false information previously published online by the JFC cult, with Mr. Woodnick's tacit assistance and encouragement. Number 5, he arranged for an excessive security detail, including a bomb squad, drug sniffing dogs, and a police escort. Welcome to the crazy world of the JFC cult. I see in her June 26, 2024 email, self-identifies as part of the Justice for Clayton Collective. Interesting term. I have a very little response to these specific allegations, except to say no. I did not arrange for the bomb squad to appear at trial on June 10th. To my knowledge, no bomb squad personnel was present. If they were, it certainly had nothing to do with me. I have no idea what drug sniffing dog blank is referring to. If there were any dogs present at trial, I did not notice them, and I certainly had nothing to do with them being there.
Actually, there are more dogs at the courthouse.
Oh my gosh, he's so snippy. Court security did provide an escort to and from court for myself and Laura. This was done at Laura's request because she had received death threats from the JSC cult members, and because Mr. Marraccini threatened to violate, and actually did violate, the DVR by appearing in court without permission. Number 6. He made unwarranted 911 call during which he followed the witness and disclosed personal information to the operator. As explained above, Laura had and still has a valid lawful court order from the state of California, which required Mr. Marraccini to remain at least 300 feet away from her at all times, without exception. On the morning of trial, June 10th, Laura informed me that she saw Mr. Marraccini in the parking lot within 300 feet. She got out that damn ruler, I guarantee. She
Right?
brought
Like,
a tape out.
there's no way I can tell you how far 300 feet is. And I don't think
Me
Laura
either.
could. I mean, that's crazy. Some people can when it's related to their job, right? Like Elevate can, because he's outside doing, utilities feet work all the time, right? But like, come on. I don't even know how far that is.
Oh, my husband can, but he also works in the oil stuff.
Right? Like
and
they
they're
kind of
always
need to
doing
know
pipe stuff. Yeah.
pipe stuff. They got to kind of eyeball things a little bit, right? It's part of their everyday life. But for the rest of us, like Laura knows how far 300 feet is.
No. She then asked me to contact law enforcement to ask them to enforce the DVRO. I initially contacted court security, but they advised they were unable to help. They specifically told me the only option was to call 911 and ask Phoenix Police to enforce the court's order, which they were required by VAWA to do. In response to the instructions from the court security, I called 911 and reported the matter to law enforcement.
Again, call 911. Are you serious?
Come
on, David. From the courthouse, where there's a whole bunch of cops everywhere. But sure, you call 911. It's a real emergency. Jeez.
For whatever it's worth, Judge Mata's division specifically instructs all parties and counsel to call 911 if they believe they are in danger of physical harm. Below is an excerpt of an email I received from Judge Mata's clerk on April 4th, 2024, which contains precisely that admonition. Are we reading that or no? It looks like a standard, like, canned disclaimer, like when you call the doctor's office and they're like, if this is an emergency, please hang up and call 911, when
Yeah.
they're not.
Yeah. If a person believes that they or a child are in danger of physical harm or are a victim of a crime, call local law enforcement or 911 should be. What? Shut up. Like, yeah.
Yeah.
People with real expectations of danger and dangerous situations. Maybe not, a courthouse. But okay.
Yeah, it's a standard instruction. I hear that all the time when I call the doctor's office to make an appointment. If you believe this is an emergency, I'm like, okay, I just want to talk to the doctor.
Right? Stupid.
Clearly, Laura had every right to ask law enforcement to enforce a facially valid on its face. Got it. Facially valid court order. I was thinking facially, but he's not talking about actual faces. Got it. Valid court order. Court security and Judge Mata's division advised calling 911 was the proper recourse. So that is what I did. There was nothing improper about this. Finally, I have no idea what he wants to say, this bitch is talking about. No, I have no idea what she is talking about when she says that during the 911 call, I followed the witness and disclosed personal information to the operator. If the witness she is referring to is Mr. Marraccini, that allegation is simply false. I stayed with or near court security personnel during the entire call. And when Phoenix police arrived, I provided them with a copy of the DVR and I explained the situation to them. I did not follow anyone, nor did I disclose personal information to anyone other than law enforcement. I assume the personal information she's referring to is Mr. Marraccini's date of birth, which is listed on the DVRO and which Phoenix police specifically asked me to provide to them. In any event, I believe this responds to all the specific allegations in her charge. If you believe I missed something, I would appreciate it if you could let me know the specific allegation you feel needs to be addressed. I will be glad to update this response if there's something further you need to know. As always, feel free to contact me with any questions. Very truly yours, David Schinkel.
David. All right. We only have just a few more things to read regarding this. So let's just move on to the next one. This is an attachment to what we just read. And in the morning of August 7th, is just them letting David know that here's a letter from the senior bar counsel, James Lee, regarding this. Also attaches a protective order that was issued in this matter. And then we'll scroll all the way up because that's where the real stuff is. So it's another email from David the day after what we just read. Regarding the state bar filing, Ms. Brokaw and Mr. Lee. As a follow-up to yesterday's emails, because I like to keep things short and succinct and be done with them, not the David way, I needed to add a couple supplemental comments regarding the charge from Redacted. After or shortly after, the timestamps on Twitter are not necessarily reliable. My response to you yesterday, Redacted posted information about her bar charge on Twitter. I did not know about this at the time I sent my response to you. I only learned about it yesterday evening. Screenshots of Redacted's tweet are included below, and a link to her post is here. You should be able to see this without a Twitter account, and it's for Tramp Stamp Esquire. Okay. I forgot he does not like that account. He was very insulted about the Tramp Stamp Esquire. You brought that one up earlier. Note, this Twitter account, Tramp Stamp Lawyer, is a parody criticism account created by the JFC cult, which is focused on publishing negative information about me. Before you ask, I have no idea what the significance of the term is. A tramp stamp. Yes. That's you? Your tramp stamp, Lord Esquire? Oh, well, he is not a fan of yours. Oh, no shit. Okay, so you are tramp stamp Esquire. Well, there you go, babe. Actually, you made it into some bar filing. So that's interesting that he's linking you to this. But okay, here you are. Before you ask, I have no idea what the significance of the term is. A tramp stamp usually refers to a tattoo on a woman's lower back. It could be any person's lower back, sir. Men have them too. I do not have any tattoos, nor does Laura, to my knowledge. Oh my God. That reminds me of the I'm not a cat Zoom hearing video. I don't know why I'm a cat, but I am not a cat.
First, maybe it's not about you, Jingris. Why do y'all like read things and assume everybody is saying something about you? I mean, it probably is about you, but you.
I mean, Carly Simon wrote a whole fucking song about it. Right or no? That was Nancy Sinatra. No shit. Which one wrote You're So Vain? I think it was Carly Simon. And Nancy Sinatra were like, the boots are made for walking. I think, is that who it is, chat? Oh,
is this where we're going to be stuck? Is this where?
Famous. Yes. She's famous.
Look, I was trying to bail you out here, Hellville. I was trying to help take you off his radar.
In any event, I have never threatened whoever is behind this account. I am blocked from following that account, so I cannot see their tweets when using my normal Twitter account. But you could like see it with a different one, which you obviously did. Hence your link. For anybody can see without an account, but okay. The reason we know Redacted posted this is pretty simple. The tweet includes a copy of the bar's letter to her dated yesterday. Although she redacted her name from the letter, she did not redact the file number 241692. Obviously, I have no issue with Redacted or anyone else posting truthful statements and fair criticism online, nor do I have any objection to them sharing matters of public record. That's how the law works. Although this is slightly ironic given that Redacted asked the bar for a protective order to prevent me from retaliating against her. As I indicated in my letter yesterday, I have no idea who Redacted is. I have never communicated with her, nor have I ever threatened her in any way. The first time I saw her name was when you submitted her charge to me yesterday. This leads to my second point. I am concerned Redacted may have misunderstood Mr. Lee's comments in his June 26, 2024 email to her. In that email, Mr. Lee advised, Redacted correctly, that statements made to the bar are subject to an absolute privilege. That statement is, of course, completely true, and I have no problem with this. However, any suggestion that Redacted is wholly immune from suit just because she also submitted a complaint to the bar is incomplete and potentially misleading. I am concerned the reference to immunity in Mr. Lee's email may have caused Redacted to believe incorrectly that she is absolutely immune from suit for any public statements she makes on social media, simply because she also made the same statements to the bar. This is absolutely not correct. Yes, Elville. He is saying that he believes that whoever ran Tramp Stamp Esquire is who filed the bar complaint, is what he's saying. So he's saying that, yeah, I didn't think you filed the bar complaint anyway. But no, he's connecting the dots here and thinks that obviously that's the same person, I guess. So there's that. Adding this to your upcoming video. Yeah, girl, you do it. That's why I think I know who this is, but I don't care to share with everyone because I don't 100% know if I'm right, if my memory serves me right or not. Anyway, but yes, he thinks it's Tramp Stamp Esquire is who it is. Clearly, while I have no intention of suing her or anyone else, if Redacted posts false and defamatory statements about me on the internet, she would be subject to liability for defamation, regardless of whether she also happened to make the same statements to the bar. I think it is very important she understands this, and I think it is clear she does not understand this. Exactly. It is absolutely redacted for a reason. Absolutely. He is so dumb. Yeah. As I explained in my letters from yesterday, it is also important for Mr. Lee and all bar staff to know the JFC cult is extremely dangerous and they should be treated as such. In addition to making false statements to you, which they believe they can do with impunity, they are huge fans of doxing anyone they dislike. They will typically publish every document they can find which supports their narrative. I'm pretty sure they put all of them out there. I don't know if I'm missing one, but okay. Or which appears to denigrate myself or Laura or anyone else they dislike. Because of this, I am confident Redacted and or other cult members will publish any and every document relating to this matter in an effort to make it appear falsely that I am guilty of some wrongdoing. For that reason, I would respectfully ask that Mr. Lee exercise caution in his future correspondence with Redacted. He should be aware that everything sent to Redacted will be posted online by her, not by me. At the very least, in future correspondence, Mr. Lee should also inform Redacted the Supreme Court Rule 48 does not provide immunity from claims arising from the publication of false and defamatory statements on social media or anywhere outside of the scope of what the rule protects. I don't think he knows. He puts everybody, see, this is where things happen, right? The whole community, he'll narrow it down to everybody's involved in every single aspect of it and use one thing and blame it on everybody. I mean, I know you didn't dox anybody, but that's what he's taking different events that he's complained about before and applying it all down to Redacted and to Truth Bombs Esquire. So I don't even think it's necessarily meaning that account doxed anyone. He's using all of it, because everybody has all the same opinions. Which I need to find the cheapest and safest tramp stamp within 5 miles of me. Like now, we can get matching ones, Negla. Just get Esquire. That's it. Why not? Yeah, who knew? See, this is why reading all the documents is fascinating for the lore as well. Now that we know who Tramp Stamp is, can we get an idea on Honk My Meat? I don't know who Honk My Meat is, actually. I know it wasn't Clayton. I do know that, or any of the guys. I don't know who that was at the time. And honestly, I think that was a Discord only thing, and everybody changes their names there all of the time. For funnies, like they'll all have several going from that. Like we all did it for TIFF one day. It was a lot of fun. So the whole word or ESQ, definitely just ESQ. That's it. Do not be giving Lyric any ideas. All right. So he goes on to say, one final note. In my letters yesterday, I suggested it is likely the bar has received or will receive many additional complaints about me relating to the Owens v. Echard case. I realize that statement probably sounds paranoid, but there was a very specific reason for that remark. One of the primary leaders of the JFC cult is a YouTube content creator named, why is that in parentheses? Named Dave Neal. Mr. Neal claims to be a journalist. He is not. Okay. Instead, Mr. Neal's primary source of income is posting self-created videos on YouTube, also known as content creators. We didn't need to put that in parentheses. Mr. Neal is also friends with Mr. Echard, and he personally attended the trial on June 10th. Mr. Neal even set up a tent outside the courthouse where he live streamed for several hours before the trial. Horror. The horror. I'll link it to you. This is his bar complaint. I'll link it to you. I'll send it to you in Discord, babes. Yeah, it'll probably just be easier. Let's see, where was I? Over the last several months, Mr. Neal has published hundreds of hours of videos about Laura and me, among other things. Anytime a new pleading is filed in Owen v. Echard, Mr. Neal will obtain a copy from the court and then sit and read the entire pleading word for word on his YouTube channel. Oh my God, the horror. I wonder what he thinks about the
Who does that?
It's wild. Why would anybody be interested in doing such a thing? It's crazy. Mr.
You should
Neal-
not make them so entertaining, Jingers. I'm just saying.
I know, right? It's wild. What is his definition of journalist? Because according to Runkle, we are currently doing journalism. Exactly. It's probably because you didn't go and get like your doctorate in journalism, so therefore you're not real. Like, okay. Okay. Several months ago, Mr. Neal submitted a complaint to the bar about me. I wasn't done with that. I'm sorry. Mr. Neal earns money based on the length of his videos and number of views each video receives. So he has an incentive to post as much content as possible and to make it as inflammatory as possible. Well, weren't you also being paid to represent your client? And, you have quite the incentive to write as many bullshit motions and inflammatory bullshit in every motion for months that it racked up like $80,000, $60,000, $60,000 to $80,000 from when you came on to the end of the case. But sure, it's okay though, because you're a lawyer. Sir, stop. Stop. How much does he think we get paid, first and foremost? Like, what? I mean, Dave probably makes good money now, but like also, it's not like a bazillion dollars. And so what? It's his job. Who cares? He literally posts new videos about Laura virtually every day, and sometimes more than once a day. This has slightly reduced since the trial in June. Several months ago, Mr. Neal submitted a complaint to the bar about me. That complaint was later dismissed, and despite this, Mr. Neal made videos discussing his allegations against me. And he posted the video, which in my view, encouraged other people like Redacted to submit additional complaints. But he can talk about it because it's about him. So he's a participant in the matter, which I think is, kind of important. It's failed YouTubers and podcasters. They're so salty that Dave is successful. That they are. Dave is successful because he's good at it. He's good at it, right? Like, you're the one who keeps writing dumb shit, but okay. Obviously, I recognize and respect my ethical duty to cooperate with any investigation you may perform. I have always complied with that duty, and I will continue to do so. Mind you, I think he is still at risk of losing his license. Chat, can you let me know if that's true? I know the hearing was taken away. I don't know if it was squashed or they're just waiting for something more. I can't remember. At the same time, I want Mr. Lee to understand that this is not a normal situation. The JFC cult has anywhere from 2,000 to 5,000 active members or more. That number is definitely higher. And they are absolutely obsessed with destroying Laura and anyone else who stands in the way of their goal. This is why I would expect the bar to receive numerous additional complaints if you have not already. This is not an indication of misconduct on my part. It is simply an unfortunate reality of what happens when you're dealing with an angry cult. As always, I'm happy to discuss further if anyone has any questions. Thanks. And so he's upset that Dave made a video. I filed a bar complaint after insane conduct and it was dismissed and he lost and he's upset about it. If anything, he just sat there and said that nobody posts anything about negative things. Okay, that doesn't make sense. He picks the weirdest stuff. Really does. Here's a picture of him reading a court document. for the change of judge. Okay, again, public information. Oh, look, shout out Del Bill. We even got a screenshot of you, Boo Bear. Look at this.
Well, not you.
Not
but
you.
Your post.
That says David S. Gingras is officially under investigation by the Arizona State Bar. This news comes shortly after we've learned that Laura Michelle Owens is currently under investigation by the Maricopa County's Attorney's Office. Justice will be served. And there's that. Okay.
It's not even a picture of Gingras. Why is he so upset?
Yikes.
It's like not even a real like they didn't even AI his actual face. Like,
right. And then this is Lee's response to whoever redacted is at what I'll just let her know. It's nothing of importance. We've actually read pretty much the same thing, I feel like, in all the other bar complaints. But what's so funny about it is like he's just like, they'll file all these ridiculous bar complaints. Sir, do you know how many bar complaints your client has fought bogus on her own attorneys? Like,
right?
like what? Because we've already read numerous. Exactly. People don't want to destroy anything. But there's that. Hi, Jupiter. Hope you're doing well today. Stopping by on your lunch break. I love that. We're just wrapping up, actually. That was the last thing we were going to read today. It's so I love when they're confidently incorrect. So apparently, Tramp Stamp Lawyer Esquire is not who filed that bar complaint. And honestly, I feel like if she was, she'd say so. So
Yeah,
know her well enough.
She had a
Oh my gosh,
birthday.
yes. Because you and Terry are birthday twins. And yesterday was Terry's birthday and your birthday. So happy birthday, Jupiter. Everybody tell Jupiter happy birthday. Happy birthday, babes. I hope you had a good day. And you're beautiful and youthful as always. I hope you still celebrate all weekend like I know Terry is. All right. I know you well enough to be like, nope, that's me. But I'm pretty sure it wasn't in the first place. But anyway, it doesn't really matter who it was. But anyway, so that's all we've got for you today. Now I get to spend the next 3 days planning everything for next week in the month of August, because we got a lot of exciting stuff coming up that we're doing. So I got a lot of spreadsheets and calendars and organizing, which is my favorite thing to do. So that's what I'm going to be doing this weekend.
My favorite thing to read. Well, to go through and go, how do you do that?
That's true. Exactly, girl. I know you. Like, yep, that was me. I don't care. Yeah, you're welcome. I hope you have a great weekend, babes. So I'll be doing that. So next week, we'll be doing all sorts of things. I hope you all enjoy this weekend. Hopefully, people aren't getting hit by weather. I know it's been crazy all over the place the last couple of days. I'm glad the fire thing is, well, I don't know if the fire thing's done, but it is here. All the smoke and stuff. I'm glad that went away. But anyway, friends, do you have anything you want to say before we sign off for the day?
No, not really. Just have a good weekend. Mercury in retrograde will be over in the next 2 weeks, guys. Just hang on.
It's fine. How dare I tweet news and fiery snark? How dare you, Hellville? How dare you? What's next Friday? Oh, I didn't say anything about next Friday yet. I mean, it'll probably be Laura stuff. I don't know exactly. I haven't put together my list of what's being covered when yet, so I can't even tell you. But today is Jupiter's birthday. So, all right, friends, you all have an amazing weekend. And until next week, go forth and be amazing. All right. Bye, friends.